I beg to mention few matters for unlisted. These three writ petitions are taken together, and they're more or less the issue are the same. Only some certain they have filed affidavit, and in that affidavit they have annexed the order, and also they have also passed another order, and for to revisit that case. So there is no point keeping that these writ petitions pending, and they are going to have a sitting on next Monday or Tuesday. So if it can be taken up at 2 o'clock for disposal, my lord.
You want to withdraw?
Not exactly withdraw, but then since on the basis of this letter, I will be submitting.
Tomorrow.
Yeah, disposal.
Tomorrow.
My pleasure, Lordship.
Yes.
I beg to mention item 21.
31.
21.
21.
Lordship, here I have just received a copy of the affidavit of opposition.
Yes.
I may be allowed some time to file reply.
MS and again London Council petitioner. Press for an is granted 2 weeks time to file affidavit in reply. This after 2 weeks.
Obliged.
My lord, I beg to mention item number 11, my lord.
Yes.
My lord, I need to file the affidavit, but Peraw's comment not yet received, my lord. This matter will be released after 3 weeks, my lord. I've taken consent.
On the prayer of Mr. T. Tagup, London Standing Council Education Department, list this after
3 weeks,
for filing affidavit.
my lord. Deeply obliged.
Your Lordship, I beg to mention item number 27.
27.
Herein, Your Lordship, we received affidavit in opposition filed by the respondent number 2 and 4.
On the prayer of Mr. So-and-so, London Council list this matter
We need,
after 3 weeks so as to enable him to file affidavit in reply.
much deeply obliged.
Your Lordship, item number 7, Your Lordship.
Item
7, Your Lordship.
7.
I have some difficulties today, Your Lordship.
Huh?
I have some difficulties today, Your Lordship.
Why?
May it be fixed next week, Your Lordship.
Huh?
Next week, Your Lordship.
No, no, after 2 weeks in the 2 weeks
Okay, Your Lordship.
on the prayer of London Council to the parties, list this matter after 3 weeks. 3 weeks. 2 weeks. Huh?
Obliged, Your Lordship.
Lordship, I beg to mention item number 8, my lord. The conducting
Item?
item number 8. 8.
8.
Yes, ma'am.
Yes.
Yeah, the conducting council is out of station, my lord, due to some health issue.
Hmm?
So, conducting council is out of station, my lord.
Who?
T. Garam.
T. Garam.
Yes.
What do you want?
Yes. This matter may be adjourned, my lord.
Mr. So-and-so, London Council to the
And also, my lord.
London Council appearing on behalf of Mr. T. Garam, London Council to the petitioners. Submits that leading council Mr. T. Garam is out of the station. Therefore,
And also, my lord,
for adjournment for further 3 weeks. Mr. President, list after 3 weeks.
And also,
Yes.
my lord, respondent number 3 and 6 was supposed to file the affidavit in opposition, my lord.
Which one?
This one.
Item 8.
Yes, my lord.
Sure, taking an adjournment. Will
Oh, okay, my lord.
Lordship, I beg to mention one unlisted matter to be taken up today at 2 o'clock.
tomorrow. What is the urgency?
Lordship, similarly situated case regarding the challenging the APC's advertisement, Lordship. They are the homeopathy doctors, Lordship. It's in regard to other cases, similar situated case.
We're making it clear, we're not installing the recruitment process. Tomorrow.
Can.
Tomorrow. Item number 1. Yes.
May it please your lordship.
Yes.
Your lordship, in this present matter, I am appearing for plaintiff, your lordship.
Yes.
Your lordship, in this matter, I am appearing for petitioner here in your lordship.
Yes. Proceed.
Yes, your lordship. Your lordship, in this matter, we have filed a writ petition as our rights are being violated by the respondent number 1 to 4 as well as respondent number 5, Your Lordship. Your Lordship, the respondent number 1 to 4 are the government department of Arunachal Pradesh, Your Lordship. Your Lordship, actually what has happened is, in the year 2012, Your Lordship may kindly see the Annexure 1, Your Lordship. In the year 2022, Your Lordship, a teaming agreement was done between petitioner herein and respondent number 5, Your Lordship. Your Lordship, after entering into the teaming agreement, there was another agreement, Your Lordship, which is Annexure number 2, Your Lordship. Your Lordship, in the teaming agreement, petitioner herein as well as the respondent number 5, we both have entered into an agreement to enter into a contract with the government, Your Lordship. Your Lordship, the government has issued a tender to provide IT solutions, Your Lordship, for the IRIS, Your Lordship, medical equipments as well as software development, Your Lordship. Your Lordship may kindly see the Annexure 1, Your Lordship, in which the petitioner and the respondent number 5 both have entered into an agreement wherein the petitioner and the respondent number 5 have divided their responsibility.
Who is respondent number 5?
Respondent number 5 is KCC Construction, Your Lordship.
That's why we're of the view that it is your grievances against the respondent number 5 only.
Previous grievances,
approached-
respondent number 5. Yes, Your Lordship. But
You approached you approached the appropriate forum.
we have approached, Your Lordship. For the previous dues, we have approached. As
Are you
the
withdrawing
present,
or what dismiss?
No, Your
Are
Lordship.
you-
There is a small submission. Your Lordship, kindly give me some time so that I can explain. Because this is a contract for 5 years, Lordship. Till now,
Yes.
60. Your Lordship, till now, 60 crores has been disbursed, out of which we have not received even a single penny. More
You-
they have to issue 85 crores. Your Lordship.
Yes, you were heard on 2nd of August.
Not
Then
second.
this
Your
court had
Lordship.
the-
Yes, Your Lordship. Yes, Lordship.
So we're of the view that this it may not be maintainable.
No, Your Lordship.
Your grievance is against the respondent number 5.
Yes.
Which
And
is
also
a
respondent
private-
number 1 to 4.
Why? Why
Because
respondent number 1?
Respondent number 1 has to issue more payments in future because it is a contract for 5 years. As of now, only
we
2
don't know. We cannot
Your Lordship,
preempt.
No,
We
Your
cannot
Lordship.
pre-
Your Lordship may kindly
Yes,
see.
mister, we
Annexure
cannot
number.
preempt.
Your Lordship, kindly Annexure 3 may
In
be seen.
future, see, in future, if there is something, doors are open for you. Nobody will stop you approaching the court, including this court, right?
Yes.
But
Yes,
at this stage,
Your Lordship, from the year 2022, we are giving. Your Lordship, we are giving notices
yes,
to respondent
Mr.
number 1 to 4.
Writ
Yes, Your Lordship.
petition
Yes, Your Lordship.
is basically even if an entity,
Ji.
unless you can show that he's performing a public function, you cannot entertain. And you are
you're
not left. Yes, you are not left with remediless. You have a appropriate remedy. You
We
have
have
the
approached
appropriate
the
remedy.
Yes, Your Lordship. For 60 crores, we have approached appropriate. But in future, if at all the amount is transferred to KCC, then we are at loss, Your Lordship.
Then you come. Who will stop you?
Your Lordship, from 2022 till now, because here
As
we
of,
have to pay
as of
salaries for
now,
more.
as of now, you are not able to make out any case against the respondent number 1. You are just apprehending.
But 1 to 4 years. No, Your Lordship, from respondent, because the respondent number 1 to 4 are issuing the DDs. That too, it is in crores of rupees, out of which we are not receiving even a single penny. We have done a lot of work
Yeah.
because we have.
Yes,
Yes.
mister, for that you have the appropriate remedy. Approach the appropriate
Yes.
remedy, not the
We have
writ
already
not
approached.
the by way of writ petition. Sir, please understand.
Your Lordship,
You cannot
if it is
file-
posted, if
You
it is
cannot
posted
file
for after
all
3
the
years,
cases. You cannot approach the file the cases any or all the cases before the writ court.
my humble submission before the honorable court is just to from here onwards to
It's-
transfer the
it's-
funds
it's-
to the joint account.
You show us
Ji.
that the respondent number 5 is function, he functions, public functions. I mean, whether he has the public function,
Along with us, both have jointly done the work, Your Lordship, for the
it's
government.
purely a, sir, it's purely a private dispute.
No,
So
Your
far as
Lordship,
respondent,
because the
respondent
government is
number
also-
one is concerned,
No, Your
There's no
Lordship,
cause
I
of-
am stating that respondent
There's
number
no
one is the
cause
chief
of-
secretary.
no cause of action is there. Please understand.
Your Lordship may be posted after 3 weeks. I'll come there.
No.
I'll explain. Your Lordship.
No, we have
Your
heard you on 2nd of August. Today, I've
Yes.
heard you also. Are
Yes,
you
Your
withdrawing or dismissing on merit?
I will withdraw, Your Lordship, but it is a serious because we have to pay salaries
See.
from past 3 months. We have not even paid a single
Mr.
rupee. My humble
Mr.
submission before the honorable.
Mister, you
Yes,
are
Your
a
Lordship.
learned lawyer.
Yes.
You are a learned lawyer. We're not
Yes, Your
supposed to
Lordship.
make you wise. We're not supposed to advise. You advise your client properly. Take his case to the appropriate forum.
Your Lordship, 3 weeks time may begin so that I can come there, over there. My humble submission before the honorable court is just give me 3 weeks of time so that I can pursue the matter.
On the prayer of learned counsel for the petitioner, list this matter after 3 weeks.
3 weeks. Yes, Your Lordship. I'll come and.
The question of maintainability will be considered on the next.
Yes. I'll personally come and I'll come.
Item number 2.
Nothing will be changed. You cannot
Your
change.
Lordship, Your Lordship,
appearing
kindly
in person.
continue. Yes, Your Lordship. Kindly,
Thanks. Thank you.
much obliged.
Yes.
May I please? My lord, on last occasion,
Yes.
record was called for.
सब मैनेज्ड है ना ठीक है इसमें तो क्या करना पड़ेगा कोशिश अपना तो
Yes.
My lord, we have the Paraguay's comment, my lord, and also the relevant,
Just wait. In that case, yes,
Yes,
you have
So
the
the-
parents comment. You have the records.
records in the sense, not the file note, but the minutes
You are,
of the trip.
you are directed to place the record.
Yes, my lord, in fact, we have the tender bids and all. What I'm told that, this tender process, they don't maintain that, that file notings, orders are issued, my lord.
It's in,
Yes,
Or-
compiled.
yes.
Yes, my lord.
Where's the, what provision has been violated?
Yes, my lord. Actually, my lord, I'm challenging the legality of this impugn NIT, my lord, which is at page 26.
26.
Yes, ma'am. This is the impugn NIT.
Yes. From class 1,
Yes, my lord.
class
In terms of this impugn NIT.
1
my lord,
AA
has been,
contractor.
yes, ma'am.
Yes.
Call for the construction of cancer institute at Itanagar. My lord, if you also come down to my lord, column, my lord, there is 6 column, my lord. We will consent to column number 4, my lord. Estimated cost put to tender. My lord, the estimated cost put to tender is 4.52 crore, my lord. And that this has been further segregated in 2 parts, my lord. Part 1, my lord, part A, building part Part B, equipment parts.
You want that the this equipment part has
Yes,
to
my
be
lord, I am concerned with equipment.
from the supplier.
Yes, ma'am. In terms of my lord's rule 143 and 150 of general financial rules, as well as my lord, manual for procurement of goods, my lord, 2022, my lord. My lord, I have no any grievance in regard to my this civil work, that is building part A, ma'am.
Yes, yes. So as that provision.
Yes, ma'am. Kindly come to
Manual
my
for
lord.
Procurement of goods and services.
Yes, my lord.
2000.
General financial rules, my lord,
Where
is
it
page 34.
Yes, relevant rule.
Relevant is, my lord, 35, man, 143, man. Rule 143, my
The
lord.
term goods used in this subject includes all articles, material, commodity, livestock, condition, purchase.
In terms of this rule 43, man, goods, this equipment, my lord, is come within the definition of goods, man.
Where is this equipment?
Equipment, my lord,
What are the?
in
what
NIT, my
equip-
lord,
What equipments?
this is medical equipment.
Pictures, instruments, spears, instrument, machinery, equipment.
May I read, my lord?
So this is definition of goods. Then,
Yes, my lord.
then
My lord, since the equipment, my lord, it's come within the meaning of definition of good, my lord.
yes.
Thereafter, my lord, rule 150, my lord. Registration of suppliers. My lord, how this goods should be procured from the my lord, by the government, my lord. That is given in rule 150, registration of supply. May I read, my lord? Rule 150, Roman 1, my lord.
Where it is
Page 37, my lord.
registration, it's okay.
Yes, my lord. My lord, with a view to establish reliable source for procurement of goods commonly required for government use, the Central Purchase Organization will prepare and maintain item-wise list and eligible and capable suppliers. Such approved suppliers will known as registered supply, and ministry and department may use this list as and when necessary. Such registered supply are prima facie eligible for consideration for procurement of goods through limited tender inquiry. They are also ordinarily exempted from purchasing bid security along with their bids. A head of department, my lord, this covers our case. A head of department may also register suppliers of goods which are specifically required by the department or office periodically. My lord, petitioner is a registered supplier.
It's okay. Nobody is disputing it.
Yes, ma'am.
What is the provision that it has to be through the NIT is only through the registered supply?
My lord, rule 150 itself says, my lord, for the procurement of goods by the government, it should be, my lord, from the registered supplier.
Only
Yes, my lord. My lord,
registration with
yes,
a
my
view
lord.
to establishing reliable resources for procurement goods commonly
It should be either from
prepare and
Central Purchase Organization.
All ministries of departments may utilize these lists as and when necessary.
Yes, my lord.
Such registered suppliers are primarily eligible for consideration for procurement through limited tender equity. They are also ordinarily exempted from furnishing bid security along with bids. A head of the department may also register suppliers of goods which are. Where's the bar that the only the NIT should be called from the suppliers?
My lord, as per rule 150, my lord, my lord, what right has been violated to the petitioner? My lord, by this impugned NIT, man, they have called.
So
Bids
as the provision where it bars calling from other contractors.
My lord, they are not registered, my lord. This class 1A category.
What is the mandatory provision here? It says may utilize
that list can be utilized, but they should be
May
registered. madam.
utilize. And then next is a head of the department may also register suppliers of goods. Nothing else.
Thereafter, my lord, as next, my lord, page 30, manual for procurement of goods. my lord. There, my lord, this definition of registering authority and register suppliers given, man.
It's
Who are the
okay.
register suppliers?
It's okay. Who is this quoting? You will have to show that the equipments, it has to be invited to the registered suppliers only, not to the other contractors.
Even then, my lord, if I assume, my lord,
And
this is-
also,
if
it's
I
a,
assume, my lord,
it's a financial rules of central government.
my lord, is this applicable to state of Arunachal
Maybe.
Pradesh, ma'am?
Will not dispute.
Yes, ma'am.
Will accept that
But
it's
my lord,
applicable.
my right of participation has been taken ever, ma'am. Had it
No,
been, my lord,
there is no fundamental right to do business with the government.
my lord, I have right to participate, ma'am.
You participate in some other NITs. You saw us as per these rules. Only equipment has to be tender for calling from these suppliers, registered suppliers only. It doesn't indicate.
That's the rule 150 says in my
50.
humble understanding.
We'll dismissing it.
And my
Yes.
lord, can you see so page
Anything
41, ma'am?
else?
Page 41, ma'am.
41.
Yes, ma'am.
Why 17, 22?
Yes, my lord.
Why 17, 22? Why two rules?
This is regarding, my lord, manual
Yes,
for
41,
procurement
where
of
is-
goods, madam. This is,
Registering authority means.
yes, madam.
I mean,
Page
any supply
41,
goes
madam.
on the list of registered. Which one you want to show?
Yes, my lord, some Roman 33, madam.
Huh?
33, madam. Roman 33.
33.
Yes, madam.
Registering authority means an authority which registers bidders for different
Category
categories.
of procurement. And thereafter, register suppliers.
Yes.
What does the register suppliers mean? Means any supplier who is on a list of registered suppliers of the procuring entity or a central purchase organization. For procurement of goods, my lord, he should be listed in, my lord, central purchase organization or, my lord, registered with the procuring entity, my lord, the procuring department. And procuring department is the department of, my lord, Director of Health Service, my lord.
Who has issued this tender?
My lord,
Who has issued this tender?
my lord, the client department is Department of Health Service and executive agency is Public Works Department.
Yes.
Well,
If,
it doesn't make
if the
a
health
difference.
department invites a tender,
Yes, my lord.
issued a tender, then you may claim.
But procuring
This
entity
is
is, my lord, Health Department, man.
this is by the Public Works Department.
But he is executing agency only, man. But the client department
He
is,
is
my
a,
lord,
he's a registering authority.
no, man.
Then
In terms of procurement, he is not registered.
this will be applicable in case the registering authority or the health department issues a tender.
My lord, Health Department is the client department.
It's okay.
And my lord, procurement is made,
Who is executing agency?
that's why I'm submitting. my lord.
Public interest, public works department.
Okay, my lord. Regarding civil works, my lord, there is no
Are
any.
you
dispute,
saying
my
the
lord.
public works department doesn't have any authority to issue NIT?
I'm not mean, but for the equipment parts, they have to follow the financial rules and this manuals for procurement of goods. They have to follow. This
They
is
have
my
to follow, but there is no bar that the tender cannot be called from the other suppliers.
My lord, it is like, my lord, the catering services are given work for construction of work. It is like that. Because, my lord, this
the-
equipments, my lord,
Be that, be,
civil work, we
Let
have
it
no
be.
dispute, my lord.
let the catering to supply will accept that.
My lord, if that is the, my
If
lord,
they-
the
if you are drawing an
appreciation of the
analogy
lordship,
from the catering,
I have nothing to say. That is the appreciation of that honorable court, ma'am. I have nothing to say, madam.
there's no bar.
But in my humble understanding, madam, here is, because this class 1AA category who has registered with APPWD, they are not a registered supplier, man.
What is the Last date of. Date of opening technical bid. It's over already.
My lord, this, my lord,
Date and time of opening of the technical
yes,
bid.
technically bid has
28.
been open, my lord.
It's over.
That has been open, but my lord, that has been given to be open on 21st of August. Prior to that, I have come before this court, since there is no any stay, my lord, therefore they have opened, but my lord, that scrutiny has not been done still yet, as per my instruction. Scrutiny has not been done. My lord, only my limited, my lord, the answer. My right to participation has been taken away.
You are not class 1A contractor.
But for the equipment, I'm eligible, man. I'm a registered supplier of.
You may be eligible, but there's no bar that the NIT cannot be issued
NIT
Inviting
can, my lord, the
from
public work,
other suppliers or the contractors.
yes, my lord, from public work department, they may be given, may be delegated with power to call for an NIT, man. But my lord, for the equipment parts, they have to follow this general financial rules and procurement of goods. Manual for
Are
procurement.
you saying that it is not the PWD, it is the health department who has to issue the tender for equipment?
My lord, power can be delegated to them, my lord,
Then
public work department, but they have to follow this general
problem is
financial.
when you, after submitting, after explaining everything, when you say, but, this but was is very, very
My lord,
problematic.
What is my humble prerogative? Let the public work department be delegated with power to call for tender, but it will be in
That's what I'm
accordance
saying.
with, in accordance.
When you use
general
the
financial
word
rules,
but,
madam.
it creates a problem.
Well, it can be through also director of health service also, but if they have given, delegated the power to the public work department, no, they can, but it should be within the
That's what I'm
bound of, my
saying.
lord, general financial rules as well as manual for procurement of goods, man. Not other rules, man. Civil work, it
Yes.
is okay, man.
My lord, the tender NIT is EPC and turnkey basis, man. Turnkey mode, my lord. If my lord says page 26, under EPC, meaning thereby the successful bidder will have to complete everything right from design, the design of the hospital in the institute, and finishing it to complete. Now here there are certain equipments which has to be installed at the time of construction itself. Now, how can these be parted? The sanction order is also one sanction order. It cannot be splitted.
According to your equipment,
There are equipments,
these are the equipments which will be installed in
there are equipments which has to be installed, my
the
lord,
building.
in the building, which later after the construction completion of the building, it cannot be installed at the time of construction itself. Like there are very CT scans and all which are have to be, what I'm told, they have to be laid, and there are gas pipe, oxygen plant.
And all these are to be installed after the completion of the building.
At the time of
Gas pipe, laying gas pipe, and
yes,
maybe.
yeah, gas pipe and the oxygen. There are so many things which has to be done at the time of construction also. So that cannot be segregated, my lord. Now, I'll come to the legal point, my lord. Whether petitioner will have a right, any enforceable right. That is the main question, that he wants to supply just because he is a registered contractor.
According to him, as per the general financial rules.
If his registration is itself same, whether that is also as per the general, his registration itself is as per the rules, that has to be seen.
Okay, you file the affidavit. Police
Will-
notice. Yes.
And already this court will see whether public interest should suffice or the private
We're
interest.
not passing any order.
Yes, ma'am.
We'll just issue a notice giving you a
Yes, ma'am.
opportunity to file affidavit, we'll
Yes.
consider.
Well,
Otherwise, you can.
Tender
stop it
bids
up
are-
today.
yes, ma'am.
Can we?
Let notice maybe issue, ma'am. Let them come up with affidavit.
Yes, yes,
I maybe get chance, ma'am, to refute their.
yes, yes.
That's the reason I'm issuing notice. Otherwise not. Because
Madam,
tomorrow
I'm-
you may say that why dispose of the motion stage,
I'm
that
over.
opportunity.
I'm
Yes. Her, Mr. H. Lampu, learned counsel for the petition, and also her, Mr. N. Ratan, learned additional advocate general for the state,
Yes. 3 and 4. 3 and 4.
state respondents 3 and 4, number 3 and 4. And Mr. T. Tagum for respondent, learned standing counsel for education, the
1 and 2.
Health Department.
Yes, ma'am.
Standing counsel Health Department. Department of Health Services, Government Department. For respondent number 1 and 2. By filing this application, no, the petitioner is aggrieved by the NIT. That is 0908/2024. Issued by the Executive Engineer, Capital Division A, PWD. Inviting online tender oblique bid in EPC oblique turnkey mode in 2-bid system within bracket technical and financial from registered contractors in the category of class 1A, class 1 double A, capital double A. APPWD or of equivalent class and category of building and capacity as per. No, or of equivalent class and category of building and capacity as per APST contractors enlisted in APPWD and contractors eligible for national and international competitive bidding as per the Arunachal Pradesh district-based entrepreneurs and professional incentives, development and promotion act 2005. 2015 for for establishment of foreign work of construction for establishment of State Cancer Institute at Itanagar, Arunachal Pradesh. With estimated cost of rupees 214.52 crore for building part A. Within bracket, for building part A, rupees 95 point, it's page 26, and for equipment part B, rupees 119 crores within bracket close. Next, the contents of the learned counsel to the petitioner is that as per the manual for what is this? General financial rules. As per the general financial rules 2017.
Yes.
17 and 2020.
22 is
17
manual
and what is this?
Manual
The
for-
manual for procurement of goods and services 2022. For the equipment part, NIT should be called from the registered suppliers and not from the other contractors. As the authority inviting tenders in the present case has called from the contractors other than the registered suppliers of the department. comma, same violates the mandates of General Financial Rules 2017 and the Procurement of Goods and Services, Manual for Procurement of Goods and Services 2022, not mandates, huh? As required under the provisions of SWENS. Issue notice returnable by 4 weeks. 3 weeks. Since the respondents are duly represented by the respective learned councils, no formal notice the serve, however, extra copies will furnished to SWENS.
Extra copies.
That's all.
Yes.
My lord,
And next para, huh? The respondents to file their respective response or before the next date.
my lord, the
Yes,
finalizing of the tender.
I'm not convinced. There is no violation.
Offline,
Sorry.
offline.
Your Lordship, highly apologize to interruption to court proceeding. Your Lordship, in item number 27, that interim order is there, so that may be continued.
What?
Item number 27, I forgot to mention that item number 27, interim order is there. So that may be continued.
27.
Highly.
Lordship, may I please?
Yes.
Lordship, here,
Hopefully you are ready to withdraw the requisition.
let me submit.
What like?
Here, violation of chapter 4, clause 4, chapter 4, clause 4.3.
We'll
The-
come, we'll go to that issue later. You
Yes.
just explain. Just make your submission
Yes.
as per the order of this court on 2nd of September.
Yeah. Item number 3. I am for item number.
Yes. 372. 372.
Yes.
Read petition 372.
Yes.
See, I'll explain to you. You said you went to deposit your bank guarantee on 23rd
Yes.
August. The last date is, and on 23rd August, office was closed,
Yes.
whatever may be the reason.
And last date.
And you filed a representation on 26
Yes.
before the chief engineer. And the last date was on 26.
26.
Instead of filing a representation, why did
Yes.
not you submit your bank guarantee on 26?
On 26, I have ADC complaint, page number 126, where I clearly mention the office executive engineer remain absent in the office, and same letter was acknowledged to the executive office. It was
20
received
on
on
26?
yes, page
On
number
26?
yes,
On
26.
26,
Yes.
office was closed?
Yes, as per
Just
SVT.
reply. On
Yes.
26, office was closed.
Office was not closed, but executive engineer remain absent.
Hard to believe, sir.
And in
So
my
as-
in
so
my
as-
complaint here clearly reflect.
Apart from your complaint, so was that you visited on, even on odd,
Yes.
that documents also you say,
Here document received here clearly written the date of receipt and hours also.
That's what I'm saying.
Yes.
Instead of going to the office to submit the bank guarantee, you went to the ADC, chief engineer, filing representation. What is this?
The last date of submission is on 26th
Yes.
and 12 till 12 noon. And
So
up to 11:30, they remain there in the
where
office.
it is? Where is the statement?
Here,
Where is the statement? Not representation.
my
Where is the
lord,
statement in the petition?
yes, para para 7.
Where is para 7?
Yeah, para 7, let me read. That the petitioner Hamid Weeks to state that on 26th of August 2024, last day of offline submission, the petitioner could not submit the site verification certificate and bank guarantee bid security before the respondent number 4. The respondent number 4 arrived late at the office and deadline of submission was till 12 p.m. Thereby, the respondent number 4 willfully omitted to issue site verification certificate and acknowledge bank guarantee bid security of the petitioner on 23rd of August till last date of submission. My lord, here clearly mentioned my writ petition. There is condition SBD 2.5 clearly suggested that petitioner has to visit the site verification, and after that, the engineer in charge, that is executive engineer, he is the engineer in charge of the project, has to issue verification certificate to the petitioner. I approached for that, it was not issued. And another condition, SBD 2.20 clearly directed the petitioner has to, the bidder has to submit offline bank guarantee to the executive engineer for taking initial, and after receipt copy of that, it has to include in the upload others tenders bids. So that opportunity was not given to me.
So what is the grounds of rejection?
The ground of rejection clearly indicate that my bid was submitted on 27.
Yes.
Because 26, he was not there. Prior to that, I visited. The office remained closed. On 27, 27 without site verification certificate issued from the in charge, that is
How do we
executive
know
engineer.
whether you have visited or not?
Here, photocopies here clearly.
Let us see your bank guarantee.
My lord, my application, my complaint before the executive magistrate, Marian, here clearly indicate the executive engineer remain absent in the office. That's why I made a complaint, and same copy was acknowledged to the executive engineer who inviting
Yes.
tender.
Any instruction?
Yes, madam.
Why you were absent
No, my lord.
on the date of
My lord,
last day?
explanation was called by the chief engineer. Detailed explanation has been given by the executive engineer. In fact, on 26 itself, the petitioner also came there, but he did not submit. He came there, he did not submit, he made only the complaint, which was also received. If my lord will see,
Yes.
the second page, my lord. The representative of bidder Sri Jotam Toko Hanan came to the division at around 11 a.m. on 26/8/2024 and submit the second page, my lord. It's continuation of serial number 1, second page. The representative of the bidder Sri Jotam Toko Hanan came to the division at around 11 a.m. on 26/8/2024 and submitted the complaint letter but did not submit his bid security or tender fee, whose date or last date of submission was on the same day on 26 so-and-so at 12 noon. Copy of received complaint letter dated so-and-so. Yeah. Rather, he came back again on 27 and forcefully entered the chamber of the executive engineer and forcefully tried to submit the bid security and tender fee papers, which the office had refused to accept, and gave the reason of non-acceptance of the bid security in written and insisted by him enclosed copy. He was asked by the EE as to why he has not submitted it when he was there.
At least there is an acceptance, admission that you went on, you visited on 26, 11 a.m. But problem is, you have not submitted the bid
Yes.
Yes, my lord.
bank guarantee.
Let me clarify.
You have tried to submit on 27.
There.
Now, whether you have tried to submit or not, it's purely a disputed question of facts. We cannot
my
go into that.
My lord, there is condition SBD 2.5 clearly indicates that bidder has to obtain site verification report from the executive engineer. Since executive engineer is not there and their certificate was not issued. And another condition SBD 2.2.
How do we know whether he was there or not? Forget about, they have accepted. He was there, you came on 26th at 11 a.m.
Yes.
But problem is you did not submit the bank guarantee.
Since my lord, that's why I'm looking for.
How do we make an inquiry on this?
My
Whether
lord,
you have,
SBD, as per SBD, I followed. As per SBD,
did you try to submit your bank guarantee on 26th?
yes.
When you visited office of the executive engineer
yes,
at 11 a.m.
yes.
How do we know?
Till I was there, but executive engineer remain absent. By afternoon, I complained made before the chief. So that's the last day.
You may be correct, but how this court will make an inquiry?
My lord, complaint letter made before the ADC and same copy was given to the executive engineer. Kindly page number 26. Here, head assistant received
It's okay.
received on the 26/8/2024 at 11:13 hours. It indicated that I was there and I was waiting for the executive engineer. to
Now,
obtain the initial.
on their submission, they are accepting that you came to the office of the executive engineer on 11, but you did not submit the bank guarantee. That is the problem.
Bank
Then-
guarantee, that's why I'm went therefore submit the bank guarantee and receive the copy,
Yeah.
1 point. And another point, site verification certificate has to be issued by the executive engineer. I'm waiting for that, but executive engineer was remain absent. So without following the SBD,
These are the two grounds which your bid has been rejected
yes, for that, without,
for non-submission of site verification and the bank guarantee.
that is as per SBD, site verification is must and the bank guarantee is a must. And for that, I
On what ground your bid has been rejected?
the late submission.
Huh?
Because my lord things say that we before uploading the
That's why for that, how this court will make an inquiry that whether you went there. We accept that they on their own showing, they're saying that you came there, but whether you have tried to submit or not, how do we find out?
11:30 receive of their complaint letter 11. It indicated I was there. That is one ground. And another ground I approached before this honorable court. Chapter 4 CPW medical.
Other day, we had a doubt that whether you visited on 26 or not. Now it's clear that you visited. You went there at 11 a.m. But now next issue is whether you have tried to submit your office the bank guarantee or not. How do we find out?
As per my lord, as per SBD, without submission of the bank guarantee in my tender will upload, there will be ground of rejection. For that, I made the representation before the chief engineer, praying for not reject my bid document without initial taken from the executive engineer. That point, I made a submission before the chief for not rejection of my tender bid. Later on, it found that my bid was rejected. But actually, my
See,
technical
last date was on 26.
yes.
Admittedly, you have not submitted till last date. You have tried to submit on 27, right?
Yes.
Then
That
how can your bid shall be the documents which is to be submitted within a period, a certain period, limit, be accepted after the expiry of that fixed period
my lord,
or fixed date?
SBD 2.20 clearly indicate the original copy of bank guarantee to
Can be submitted even after the last date of submission of the bank guarantee.
prior to the
Show us.
pre-
Show us. If that is the case, we'll stay. Show us.
the bank guarantee shall be deposited to the
Page-
executive
page-
engineer. Page 57.
57.
Yes.
Yes. Where
It's
is
a
this?
middle line. Let me read from the past 2.201. The bidder shall furnish
2.201.
2.20.1.
Yes, the
Middle,
bidders shall
middle
furnish
line.
accordance with the bid
The bank
certificate
guarantee shall be deposited to the executive engineer Mariang Division PWD, and a copy of receipt is to be uploaded 1 day before opening of the request for proposal. Here clearly given 1 day before of last date of upload, this bank guarantee to be submitted before the executive engineer. But that opportunity I was not given. I visited there, the executive remained absent.
Where it
Due
is
to that,
said? 1 day
that-
before the last day?
this bank guarantee shall be deposited to the executive engineer Mariang Division PWD, and
It's to be
a
uploaded.
copy of receipt is to be uploaded 1 day before opening of the
This
request
bank
for
shall be
proposal.
deposited. Copy of the
In order
receipt
to
is
comply this SBD, I went there, waiting till noon of the 26th, but the executive engineer remained absent. Due to that, I could not submit my bid on 26th because this is part of formalities instructed by SBD. And 2.5 here also. On next page, any bid 2.20.2 here also. Without following this, my bid to be rejected on that ground. My next paragraph, next page 58, page number 58, 2.20.2. Any bid not accompanied by the bid security shall be summarily rejected by the authority, a non-responsive. See,
Yes.
in order to prevent this, avoid this rejection ground, I went there to deposit my bank security before the executive engineer, but executive engineer was not there, not acknowledge
So
my
these
bank
are
security.
the clauses under which your tender has been rejected.
Yes, the ground of rejection of my tender paper.
Hmm.
And here 2.5 also site verification report. It has to be issued by the site in charge, that engineer in charge of that project, that is executive engineer himself. So in order to submit my entire full document in the upload in a tender paper as per instruction, since respondent authority, that the executive engineer is not issue the site verification report, I could not submit my tender bid as per last date.
Yes, it says this bank guarantee shall be deposited to agreement so and so, and a copy of receipt uploaded 1 day before opening of RFP.
Yes.
Yes.
Yes, yes. Bharat will kindly come to page 29 itself.
29.
Yes. Page
Hmm.
29, here itself it is given. And serial number 4, 1.3, physical submission of original bid security, POA, 26/8.
Page 29.
Yes, madam.
What is this? Okay.
Serial number 4. Physical submission of original bids, original bid security, POA, etc. 26/8/2024 up to 12 hours. Then,
Opening of technical bids.
yes, my lord, prior to that, last
Okay.
serial number 2 is last date of submission of hard copy of bid is on 27.
Yes, that's why I submitted on 27th.
27 is the date of submission of hard copy.
Yes.
26 is
Where it is? What it says?
serial number
Serial
2
number 2.
Last date of submission hard copy of bid.
bid is
27.
27 up to 11 hours.
Physical submission original bid security.
POA, etc. is 26/8/2024 up to 12 hours. Now, my lord,
Yes.
my lord, we could understand.
Yes,
Yes,
that's
we-
why 26 was last date. And the opening was 27
Yes.
at 12 noon.
Yes.
From 26/12 noon to 27/12 noon, it's 1 day. 1 day before the
Yes.
Yes,
opening.
yes.
That's why you could have submitted.
That's
on
why
twen- on
for
26.
submission, for offline submission, the security,
Not
I went
Mr.
there.
My lord, may I further clarify?
Hmm.
He, when there, he made only a complaint.
Hmm.
He could, even if assuming that he had the bid security in his hand, he could not submit it because there was no site visit report. And for that site visit, he has to apply for site visit, my lord. If my lord will kindly see the instruction, my lord, that explanation. No application was submitted that he for site visit, because site visit he himself cannot go. There has to be a certification. A technical person of the department has to go along with that bidder.
You file an affidavit.
Yes,
I'll
ma'am.
consider.
We'll file affidavit. He did not file any application seeking that we will go for site visit, and it has to be accompanied by
What
the,
is your prayer?
My prayer before this humble court.
yes, my lord,
So
that
that
also.
irregularity is there. So
To
I
stay the
prayed
tender
for
process.
yeah, tender
Yes,
process.
exactly. I was,
Only stay the
And
tender
the
process.
next after intervention of this humble court, the discretion is left to before the humble court. So any order, because since arbitrary is there, so any appropriate
This,
direction.
See, your
without the-
prayer has
And
to be,
meantime,
your prayer has to be very specific.
yes,
Neither you are making a prayer for rejection, setting aside or of your rejection, nor you are asking for consideration of your bid, only for stay the tender process. How
Af-
can be
after-
allowed? Even if you establish a case, on this prayer, we cannot pass.
yes, my lord.
meantime,
No,
That means the,
relief can be granted on this.
meantime, I'll file application for amendment of the
So
my
till that
petition.
time, you file it and then we'll issue notice. You
My
file
lord,
affidavit.
that is one ground. And another ground, as per CPW manual 2022
See,
29.
Basic
Time
prayer,
period.
there's no basic prayer, no specific prayer. Even if you establish your case by your argument, even if you agree, accept your argument, will not
well-
be able to pass any effective order granting you relief. Heard, Mr.
My lord, well, in that case,
T. Toru, learned counsel, you'll issue notice. Whatever you want to do it, do it. Learned counsel for the petitioner. The petitioner challenges the tender process. Number one, tender process, page 26.
NIT 21. Page number
Page
21. Page number 21 NIT.
21.
Yes. NIT dated 16/8/2024.
No. You just start. Challenging the NIT. Notice, challenging the notice inviting bid dated 16/08/2024. The petitioner has prayed for stay of the tender process only. Please stop. It is submitted that by the learned counsel for the not submitted. It is the contention of the learned counsel for the petitioner that his bid has been illegally rejected, as the petitioner visited the office of the executive engineer, Mariang, PWD division, to submit his bank guarantee on 23rd, as well as on and 23rd/08/2024, where he found the office closed. Thereafter, the petitioner visited on 26/08/2024 at 11 p.m. and made and tried to submit the bank guarantee as well as requested for issuance of site verification report.
Site verification report certificate.
However, since the on 26/08/2024 also the office of the executive engineer PWD Mariang division was remained closed.
No, not closed, but executive engineer was not available.
Though the office was open, the executive engineer was absent. List of having no alternative, he filed a representation before the ADC Mariang
ADC as well
as well as the chief engineer PWD. List of, however, without considering the grievances raised by the petitioner, his bid, his technical bid is rejected on the ground of non-submission of bank guarantee as well as site verification report, which is not sustainable. Issue notice returnable by
My lord,
4 weeks.
my technical
4
bid-
weeks technical bid.
Not technical. My tender paper was not accepted. In fact, technical bid was not open.
No,
My tender paper hard copy was not accepted.
okay. Then the instead of technical bid, tender papers, hard copy of the tender papers have not been accepted. Since Mr. N. Ratan, additional AG and Mr. T. Tabu. You're for respondent number 5. You're
My lord, they have not pleaded also, though we have participant and all the participant fund they have not.
have you filed caveat?
Yes, I have participated.
Okay. Mr. T. Tabu, learned counsel for the caveat. Enters appearance and accepted notice. No, accept. How do you, okay, how can we hear you if you are not a party?
My lord, we'll have to get in place, my lord. As a caveator, my lord, that's for on aspect of the interim, we caveat, that's to it. As a caveator.
Then you said you just delete his name, huh? No, for formal notice need be served. Extra copies be furnished to this ones. Mr. T. Tagum, I heard Mr. T. Tagum, then counsel for the petition, caveat the chairs, stands the chairs, huh? In caveat, huh? Either you implement them or you implement.
Yes, if they don't implement, my lord, it is defective, it become the petition would be defective.
Otherwise,
Because,
otherwise,
party has to be-
my lord,
List after 4 weeks.
I may be allowed to file a press
Press.
petition. Yes. Otherwise, since at age of now,
Will impose you a cost. You have wasted yours and this court and all everyone's time for another
since the other
30
party is
minutes.
intending of this,
Will allow you to withdraw to file and fresh, but then will impose cost,
no problem.
which no
I'm
problem.
ready. I am ready to comply.
Is it?
Yes.
Not Mr. Titorum. In that case, you just strike a ball. Learned counsel for the petitioner. After arguing a matter for more than 30 minutes, has spread for withdrawal of the writ petition with a liberty to file press. Mr. Press allowed. The writ petition is then dismissed on withdrawal with a liberty as spread for. Problem. Last chance
I apologize for that.
for cost. Yes, any information?
My lord, so far inside regular DMO is not there, but in charge, it is informed that the reliever has not come. That's why he has not been
This
released.
cannot be.
My lord, that is not.
You direct, we'll keep it pending, we'll take it up next week. You
Well, they are in
Advise
connection
them.
from the higher one.
advise them to release
My lord.
immediately. Or Mr. Ketari, learned counsel for the petition. On instruction, Mr. Tithagop, learned standing counsel, health, Department of Health Services, submits that since the reliever has not joined in place of
Petitioner.
petitioner, the petitioner could not be released. Next paragraph. Having found the ground of on consideration of the grounds of non-releasing of the petitioner from district hospital Koloriang to Gyatitaka Hospital Zero,
Yes.
General Hospital Zero, to be unacceptable, the learned standing council is advised to take steps. If appropriate step is not taken, this court will pass appropriate orders on the next day. You advise them to release immediately, whether
My lord.
reliever, no reliever,
My lord.
That may be fixed.
after a week,
My lord.
next week.
My lord.
We may draw some adverse comments, remarks also.
My lord.
It's your duty, bring the reliever, release him.
That is right, my lord.
And man has served for 12 years.
My lord, my lord.
There was reliever, but they return again twice.
Even DMO is out of station.
Yes.
It's only in charge.
Yes, sir.
Meet legal lordships.
What is this?
Miller, I'll just briefly explain the facts, Miller, then I'll take your lordships to the paper.
Very short.
Yes. Miller, what happened in this matter? The petitioners as well as the private respondents all were Miller extension officer, rural engineering in the rural engineering department.
Yes.
The private respondents were junior to the petitioners. Miller, DRDA came into existence. There was an office memorandum of the government of Arunachal Pradesh wherein decision was taken how to take officials to DRDA. Now, what happened, Milord, the private respondents who were junior, they were sent to DRDA in a post of technical officer, rural engineering, initially. There is a post, there is a nomenclature of post that is technical officer, rural engineering. Thereafter, they are taken to the next higher post with higher pay scale, that is assistant project officer, rural engineering in DRDA. Now, a decision was taken to wind up the DRDA, Milord. After that decision, Milord, the government of Arunachal Pradesh issued the Gazette notification saying that there will be wholesale absorption of all those employees.
Let us see the impugn order.
Yes, Milord. The impugn office memorandum 154 page. I am challenging this to the extent of the private respondents.
154.
154 million.
The government of Arunachal Pradesh pleased to
Annexure P11.
discontinue district rural.
Existing 588 DRDA employees shall be absorbed and taken over to the Rural Development Department as approved during the cabinet meeting so and so, so and so, so and so. Decision was taken that 588 employees will be absorbed, DRDA.
Yes.
Overlooking the fact that there were there were persons who went from rural engineering department to the DRDA on deputation. They were holding their lien back in the rural development department. So after winding up with the DRDA, those persons should have been sent back. That is the rule of deputation, my lord. But there is a wholesale absorption and they were given pay protection. Page 155, my lord will kindly take up.
How you are affected? How you are affected?
The persons who were junior to us, you know, what happened? All were in rural development department in the post of extension officer, rural engineering. We, as well as the private respondents. Private respondents were junior to us in the extension officer, rural engineering. They traveled to DRDA in the post of APO rural engineering.
Yes.
The pay scale of APO rural engineering is 2 levels higher than us.
So
They went there,
yes.
they enjoyed there. Then there was a decision that DRDA will be wound up. Now, pay protection is given to those persons who were junior to us, who went to APORE by virtue of this notification. What will happen? In the rural engineering department, in the cadre of EURE, there will be 2 sets of employees. We, the petitioner, who are still languishing without any promotion in a lower pay scale, and there will be person junior to us.
Absorbed and taken over by the rural development department.
Yes, Lordship will kindly come to page 155.
Hmm.
Lordship will see. The governor of Arunachal Pradesh is pleased to order so and so 588 with the employees of district so and so, their own grade and scale of pay. Employees of DRDA, Arunachal Pradesh in their own grade and scale of pay as shown in Annexure 1 in the Department of Rural Development of Arunachal Pradesh as dying cadre post under the following terms and conditions.
They came back to your department.
Yes.
Are you employees of RD, rural development?
Who? We are. Yes, my lord. We are senior. We are senior than the private respondents.
So
They travel to DRDA.
private respondents who were junior to you
Yes.
travel to
DRDA.
DRDA on
Got,
deputation.
we are getting 50 rupees. They got 100 rupees.
Okay.
Then they, after winding up, they came back to rural development department. That 100 rupees has been protected by this impune office memorandum.
So what is the level? What is the post?
We are in
there
level
for the-
6. As of now, we are stagnating in rural engineering
I
EORE
mean the
post.
lower post.
No, yes, feeder post.
Now these respondents have been absorbed in the higher post.
Yes, no. What they have, the respondents has been absorbed as EORE, but they are given the pay protection of deputation during the DRDA. How can it be? Deputation, your lordship.
Your post and the private respondent post are it's same post.
Same post.
Equivalent.
Here, lordship will kindly say.
You claim for that. You claim for that. You claim for your
Stepping up of pay.
Yes.
That is one aspect of the matter.
that,
Because
that you may have the otherwise
no,
absorption and all this all policy decision.
no, I understand. My lord, policy decision, my lord, lordship will kindly aware. Because there will be seniority dispute also. Not only pay, there will be seniority dispute also, my lord.
If they don't rectify, you come back. We'll see.
No, that's why, my lord, I have challenged this OM.
Yes, you claim for the same benefits which are granted to them if you are working in the same post. Whether you are senior or junior, let us not venture on
Seniority
into it.
dispute will be there, my lord.
Okay, that
That seniority dispute, that's why I'm
see,
saying,
that will be decided by the authority. If they don't, you come here. You come.
mate, will just take your lordships with the office.
But you may have a right to claim for the same pay, the grade or whatever
Yes.
benefits given
Yes.
to them
Yes,
if you are serving in the same post.
yes.
Because there cannot be a senior or junior
Correct, my
getting a
lord.
better
Stepping up of
issue.
pay,
That-
absolutely, lordship is
that
absolutely
you may
correct.
be entitled. We'll
Yes.
consider that. This is your one of the grievance here.
This
Is it your one of your grievance here?
Yes, yes, my lord.
That will consider, will issue notice, that's all. Absorption one not stay.
No, my lord, why I am praying, I understand, my lord. I am not against 588 employees. I am not against
See,
all. What
You-
I am
you
against is that,
appears to be, if they are provided at a better pay or benefits after absorption,
yes,
they will also consider the same benefits to you if you are serving in the same post,
yes.
whether junior, not
If
junior.
stepping up of pay is given to us, my lord, There is no problem.
We'll consider that.
Yes, Lordship will
Definitely,
consider, but till
I mean,
then, my lord,
definitely, but the absorption we cannot.
no, I'll just take your lordship with one document.
It's okay, I've understood.
I'll just take your lordship with one document. Lordship, the
Of
office.
course, why not rejecting your grievances against the absorption? We'll consider that. But for the interim today, for today,
Yes,
I'm saying we're not privacy on any ground to stay the absorption order. We'll
Lordship
consider.
Lordship will, yes, Lordship is
them
absolutely
come with the
correct.
response.
Stepping up of pay is one aspect of the matter. But prima facie, if your lordships kindly consider one aspect of the matter, what is deputation is all about?
okay.
I'm in deputation. I have
Sir,
to
we'll
stand
consider all this. Let them file a response.
there. Till then, my lord, if they come and join, their pay will be protected. This
okay.
matter will-
It's a good ground for you to get this benefits. It would be a good ground for
True,
you.
my lord. That stepping up of pay, absolutely.
And
fine.
I think the government will be, they'll consider your grievances. They
Pay-
cannot, they
my lord,
cannot blindly,
my lord, pay, I am never worried.
they cannot discriminate like that.
Yes.
Definitely,
pay-
I'm sure they'll consider.
Look, I am never worried. Not the main worry is that we are stagnating since then.
Seniority.
Now APORE is a higher post. As per in our rural development department, our next,
See, reason is very simple. You have to see the other side also.
yes,
When they, this, DRD has already been rolled up. Where they will go?
no,
If
I'm
we
not,
stay this.
no, they,
Yes.
rural development department, they have a lien post in the URO.
It's okay.
So that is why.
If they are getting the benefits which
I
have
am
not been extended to you, you have a right to claim for that.
I understand, my lord. Stepping up of pay, my lord, I have
Yes.
expressed my mind, my lord, I don't have any problem. But the problem is with regard to seniority. If they don't come back to the URE, they will be getting higher pay in a higher post.
Okay.
That will be, my lord, seriously discriminatory, my lord.
Yes, that will
So
consider.
that
That is also
is
a,
the difficulty.
That's what-
Seniority should not be disrupted. That's why, my lord, I am praying that qua the private respondents. I'm not saying 588, your lordship will
no, they have
stay.
not decided the seniority as of now.
Yes, madam.
No, we are senior. I have annexed the seniority list.
Anyway,
I'll just show.
no, they have not prepared
Decided,
and the seniority list
When
or
they will be placed in a higher post, they've been giving higher pay scale. The conclusion is obvious.
no. See, if they are higher post,
We have no
The-
recruitment rule
no,
for
no,
APORE.
huh?
We have no recruitment rule for APORE.
So they cannot be APRO.
Till date, we do not have any recruitment.
So there cannot be appointment or promotion to the APRO.
We have APO Tech, yes, madam.
Huh?
APO Tech, APO Technical.
We'll consider all this.
Lordship, I'm
But
just
why don't you
explaining
take
his
this?
submission, Miller.
Yes.
We are in URE. There is no recruitment rule for promotion to the next higher post as of now. No recruitment rule frame. We are stagnating in URE since our initial appointment. Now, what they have done, Milord, they have absorbed them as APO RE. Our next promotion is APO Technical. Cadre strength is 9. This APO Technical post is equivalent to APO RE with the same.
It's okay, we'll consider everything. Let them file a response.
No, kindly.
Heard
There
Mr.
will be serious
SK Das.
penalty dispute.
Yes,
At least.
they are
qua
yet to settle that.
Yes,
They've
ma'am.
settled it.
Yes, madam.
They have not issued any order for that. They have been just absorbed. It's their job to balance, give the
Milord,
equal treatment to all the employees.
Absolutely fine. Had there been within the principles of law of deputation, my lord, because your lordship is absolutely aware of the fact that if one is gone on deputation, then he has to come back. If the deputation period is over, repatriation is
It's okay, we'll consider everything.
Lordship will kindly
SK Das, Learned Counsel for the petition.
consider with regard to this private respondents, I'm not again 588, my lord. Only with regard to private, there will be serious head burning, my lord. Serious head burning.
No, it cannot.
My lord, persons who are junior to us from 7, 7, 8, 8
By,
years,
agreed by the
that my lord will kindly consider.
absorption of, agreed by the notification dated 22/02/2024 issued by the Chief Secretary to the Government of Arunachal Pradesh, whereby on the winding of public discontinuation of district rural development agencies in the state of Arunachal Pradesh, comma, existing 588 year the employees is sought to be absorbed and taken over by the Rural Development Department. And the consequential, this is already absorbed.
No, no, my lord. Decision was taken and these are the modalities. Lordship will see
No,
Uh,
second.
the existing pay scale,
155.
page one, yes, my lord.
Oh, no, it's
Thi-
pleased to
this
order
has
for
not been given
absorption,
effect
so
to.
and so.
In their own pay.
These are the modalities, that is, serial number 3, the existing pay scale under DRDA shall be.
They are yet to come. It was a February 2024. Not
Yes.
yet.
I
not-
have made
It
categorical
was given
statement,
effect.
Not yet, Mahal.
not yet. So that's why, my lord.
And the consequential order dated 22/02/2024. Whereby the 588, they said 588 post with employees of DRDA has been absorbed in their own grade and scale of pay, the petitioners have filed this present writ petition,
Only one thing, just may I like to just show, page 157, Lordship will kindly come. Serial number 60 to 75. Lordship has seen
serial number 60.
60 to 75, APORE, the post. And grade pay given is 5,400. These are, all these persons are junior to us.
60.
Yes, my lord.
60275.
Yes, 602
So
75.
these are the private respondents.
Yes, these are the private respondents. They are given 5,400. We are still languaging 4,200. That is with regard to pay, and they will be given the seniority in the next round.
The Mr. S.K. the learned counsel for the petition contended that the private respondents who are junior to the petition have opted for DRDA on deputation. Please stop. Now, the state respondents have sought to observe them in the department by placing them above the placing by
EORE, in the
Granting-
category of EORE.
granting
Pay protection.
higher granting pay protection
Yes,
and other
in the category of EORE.
pay scales and other benefits in the cadre of APORE,
EORE.
EORE. But they've been given APORE.
Yes, APORE pay has been protected. APORE post abolished in DRDA. They will brought back to EORE in our post with a higher pay, and they will be given the consequential seniority.
Mr. In other words, the private respondents have been brought back in the same post by providing higher pay scale in the post of EORE.
Yes,
EORE.
yes. EORE.
You are also EORE.
I am also EORE.
EORE, which would clearly demonstrate which is discriminating in nature, which is discriminating. Issue notice returnable by 4 weeks. Mr. Mr. BP, Standing Constable RD, enters appearance on behalf of
2 to 4
and the appearance and accept notice on behalf of respondent number 2, 3,
and 4.
2, 3, and 4. P. Pangu for respondent number 1,
Well, this private respondent, how can we serve, my lord? My lord, may come page 8, my lord. This would be difficult for us.
Get the address of the private respondents, my lord. That's why, my lord, I am praying that they may be served to. I'll
The
furnish
notice
all
that
the.
they have to serve, now they are shifting the burden to us, my lord.
I'll furnish all the copies and I'll assist my friend also.
Mr. SK does the concern, the petitioners to serve, take steps for service of notice upon respondent number 1, sorry, 5 to 15.
Through the director.
Through the Director, Department of Rural Development. They have been absorbed.
Absorb, my lord, because there is no recruitment rule. We are in the process of framing recruitment rule, my lord.
They are yet to be absorbed.
No.
Where are they now?
They are in the my lord, department only, my lord, now.
Then, if you have difficulty, come back. Or if they are walking under you,
Yes, my lord.
what would be the difficulty?
Yes, obviously they are.
So the Director, Department of Rural Development, Government of our within 2 days from today. The absorption in the interim. Oh. What interim could be passed? No.
My lord,
Yes, my lord. The main prayer is dangerous, my lord.
I
For
am praying for
quashing of entire order, my lord.
No,
In
my
that
lord.
case, 588, my lord, this
No,
beneficiaries should
My
be
lord,
made as a
kindly
respondent.
Page 33, my lord will come. I have specifically stated stay of the impugnator for the private respondents. So far as the private, no one else.
Will not say.
My lord, page 33,
The-
the last paragraph, my lord, down below. Pending disposal of the petition, graciously be pleased to stay the impugn so and so. So far as the private
Or
respondents
page
are concerned.
32, my lord, may please prayer 1, my lord.
Prayer 1 is my main prayer, my lord.
Main prayer, my lord.
My interim prayer is only with regard to the.
In that
private
case, my
respondents.
lord, all the
Consider
beneficiaries, my lord.
submissions of the learned counsel for the parties. Come on, no. Consider. In the interim, the absorption of the private respondents shall be subject to outcome of the.
Should be stayed, my lord.
No.
Apparent discrimination, my lord. Apparent. Prima
Not the
facie
interim,
discrimination.
not interim. The absorption, it is provided the absorption of the respondents, private respondent number 5 to 15 shall be subject to outcome of request. You cannot deprive them.
They will always get, if I.
No, if we stay, where they'll go?
Yes, my lord.
If you stay the absorption order and they pay, and
If your lordship stay I'm just answering your lordship's query. I have also thought it, my lord. If your lordship stay, then they will be brought back to the lien post wherein they were still holding the
that
lien.
we cannot.
No,
that-
that's. my lord,
Before we adjudicate the matter,
Lordship.
we cannot pass there. That will be, we cannot pass blanket.
In fact, my lord, what I felt that, my lord, department.
That is, you are showing
Apart from
they are showing the way out.
My lord, whatever, I'm
But
fine.
then we'll have to think about other,
The major
we'll
mistake
have to
is,
balance.
so my lord, lordship, fine.
See, if you succeed,
Yes,
they will be out. They will be out,
yes.
but never think of, always be, live and let live. You
No.
ask your right. Don't
Yes,
destroy the right of the others.
Yes,
No,
my
no,
lord.
that's
My lord,
true, my lord.
the interim prayer are
That is
granted.
subject to outcome. Tomorrow,
Yes.
if it is not there, you may say that.
Yes, my lord, lordship will consider, yes, fine, my lord. But what I found is that, my lord, the major flaw that had happened herein is that
Maybe,
the
maybe.
fundamental principle of that
Yes,
petition
we'll
has
see.
been, my lord, everything.
We'll deal with that. It's okay.
So that's
Obliged.
highly agree.
Yes.
In this case, my lord, I am appealing for respondent number 6 and 7.
Yes.
And we are filing a affidavit in opposition course of the day.
Okay. Heard, Mr.
Y. Dolu, Senior Panel Counsel for Indian Army.
Okay.
And matter may be fixed for the after petition. That may be given because I was out stage.
Non appears for the petitioner on call. Are you appearing?
No, my lord. I
On
am
call?
for the respondent.
Mr.
Y. Dolu
Wade Dolo, learned, standing counsel.
for Indian Army. Yes. Senior Panel Counsel.
Senior
Panel council.
Panel Council for
Union of India.
Union of India. Press foreign is granted 3 weeks time to 4 weeks time to file affidavit.
It may be fixed. No,
And then, are you appearing?
no,
Mr. D,
I
come to,
appeared for the
Mr.
respondent
D,
number
come
eight.
to London Standing Council for Land Management. And G at the
For 9 and 10, I
Uh,
have filed already.
additional senior government advocate are present.
Lots of.
List after advocacy, list after 4 weeks.
That may be given.
Give that
22nd.
22nd of October.
Online.
Yes.
Sorry, may I please allow? My lord, in this case, respondents 2 and 3 have filed affidavit, but 4 and 1 have not filed.
Yes. 4 and 1.
Yes,
Yes. What is the matter?
eviction, lordship.
Eviction.
Yes,
2 and 3 have filed.
yes.
Yes.
Lordship, recently Director Housing, Lordship, Standing Council has, Lordship, they are not appearing for the housing. I'll
It is
take
Standing Council.
instruction from the Housing Department.
But where is your stand, Deputy Commissioner?
Deputy Commissioners, Lordship, Lordship, Deputy Commissioner, Lordship, we have a complaint addressed to the Deputy Commissioner as per the Lordship, encroachment of the quarter, Lordship. So we have taken action, Lordship. The ADC, Age Estate Officer have taken action, Lordship. Estate Officer, Lordship, has given so-called notice, eviction, and then hearing was taken place, hearing has, and then the Lordship order accordingly.
And Mr. Endagan, Learned Council for the petition. Yes, the Learned Additional Senior Government has submitted that she has filed the affidavit on behalf of respondent 1 and 3.
2 and 3.
2 and 3. Then you want to file?
No, my lord, the separate everything to be.
Mr. D, come to Learned Standing Council. Land Management. Submits that the reliance should be placed on the affidavit. The department, the respondent number, he would rely on the affidavit in opposition filed by the respondent 1 and 2 and 3. You inform the standing council, will give another time
Yes,
because he's the complainant,
yes,
respondent number 4.
yes,
5.
4.
4. Okay.
Lordship,
The Learned Council for the respondent number 5 is granted further 3 weeks time to file affidavit.
Lordship,
Interim order pass earlier shall continue. Huh?
4, Lordship.
4, sorry. Respondent 4, huh? Is granted further 3 weeks time to file affidavit.
Lordship, what I have submitted is that Standing Council for the UD, he's not the council anymore, Lordship. So I may be given some time to take instruction from the Director Housing, Lordship.
Oh, so that's why I'm saying. That's why I didn't say, I said respondent number 4 will
Yes,
granted 3 weeks time to file
yes, Lordship.
affidavit. You take instruction and file it
Yes,
immediately.
yes, Lordship. Oblige. Oblige.
What about 9? Okay. That's it. 10. What is this?
Regarding compensation, madam.
What compensation?
Yeah.
Affidavit,
Not, they are
claiming this 100% solution.
Hmm.
So, my lord, there are a series of cases, my lord.
Hmm.
And my lord is aware of the fact that
So I cannot take it down.
yes, and more so, my lord, the SLP, my lord, filed by one Mihing Laling that is pending in the apex court, my lord. In view of that,
But
my
then
lord,
You filed an affidavit. Can I take up this? No,
no, my lord,
I cannot.
no, my lord, because my lord, this is the issue involved the same thing, my lord, which it was dealt in the case of Mihing Laling, my lord.
They are relying on this.
Yes, my lord.
Okay. List this matter before any other approval do it without me. Yes, sir.
My lord, I'm appearing for Mr. Kato on behalf of.
Yes. No office note. Where is the office note? Why no office note? Hmm? Yes, what is to be done today?
My lord, in this case, I have little submission, my lord. Here, my lord, regarding item number 12 and 14, my lord. Item number 12 and 14 relates to, my lord, this benefit, denial of the benefits, my lord, credits. So that as per the Amendment Act 2024, well, section 16(4) has been amended. Now they can claim their benefits up to November 2021, my lord. Date has been extended. So, my lord, these cases will be disposed of with the remanding back to the adjudicating authority to decide as per the law, my lord. Present law, my lord. As amended law.
Unmute.
Lord, yes,
Other
mine
side,
is
other
unmuted.
side. Other side.
My lords,
Okay.
my lords, am I audible?
Yes, yes.
My lords, they may file a counter in this regard that incorporating this fact that the recent amendment has been there. In fact, my lord, they themselves are dropping the demand, and he may drop the demand, and then we may withdraw it. My lords, am I not audible, my lords?
Yes, yes, please go ahead.
My lords, I am saying that they may file a reply in this regard that with respect to the recent amendments.
Yes. Have you filed your counter affidavit, Mr.
They
Boro?
have not filed the counter
No, my
affidavit.
lord. We have
You
not
file
filed.
it
My lord,
with-
because my lord, the law has already amended, my lord. Now they have been given the chance. This everything is amended in their favor. So simply they should approach the authorities. So the matter may be remanded to the authorities. They will just decide as per law.
See,
The time frame may be given within a period of 2 months, 3 months like
They are
that.
themselves the authority.
if the law might have been amended, but then will it have a retrospective effect?
My lords, the law has not yet been amended. It has been the Finance Act 2024 has been notified in the Gazette of India. However, it specifically says that this provision shall be notified as on when the notification will be issued by the
Same.
central government.
Mr. Boro, whatever you want to say, you bring on record. We'll decide. All right.
Okay, my lord. My lord.
My lords, if the situation is
Because
this, then
even assuming, accepting that your the law has been amended, even if the law is amended, whether it will
My
have
lord.
a retrospective effect or only a prospective, we'll have to
my
see.
lords, the Finance
Isn't it?
My
Act,
lord.
my lords, the provision, a new provision.
It's
section
okay.
16
We'll allow them 3 weeks time to file response. All right.
My lords,
My lord.
Heard Mr. So and so, so and so. Huh? the Mr. K. Boro.
Age
M-
of-
MK Boro. MK Boro, my
K.
lord.
Boro, learned counsel for the respondents is granted further 3 weeks time to file their response. File affidavit in opposition. List after 3 weeks.
Maybe, my
List
lord, after
after 3
vacation, my
weeks.
lord. My lord, after vacation, if possible, my lord.
So make it 4 weeks.
My lord. In 12 to 14, my lord, all the three matters, my lord.
Keep that in. Also. Next.
Obliged, my lord.
This matter may pass over for time being, madam.
Why?
Yeah, madam. Senior government advocate is appearing, madam.
Who?
His senior government advocate, madam.
What is the matter?
I have no idea, madam. This is a review petition, madam.
Who appears for the, you are for petitioner, review petition,
Review petition is on behalf of,
service not completed. Had MS Show, T. Wang Molan State Council. Office note dated 040924 reflects that service report in respect to respondent number 1 and 2 are still awaited. Let the matter be listed after. Listed after 3 weeks, awaiting service report.
May my lordship.
Yes,
My lordship, we need some more time to file affidavit.
what is the matter?
Compensation.
You have to take steps.
Yes, sir. Sir, like, I would like to mention that, like, we have taken the step multiple times, but the
When-
report
when?
is service. Sorry, sir.
When did you take the steps?
Uh,
There is also no,
So after we got the direction from the court, we have taken the steps, sir.
there is no office note. Again. Tell them. Oh, sorry, it's here. Ever service report.
Sir, in respect to the order dated
service-
3/5 of this honorable court, I would like to mention as per
Ever
the
service reports for another 3 weeks. The learned counsel for the state respondent. Ever service reports in respect of respondent number 2
no, sir.
for
we-
another 3 weeks. In the meantime, the state respondents may file their affidavit. Yes,
Sir, if I can mention about in respect to respondent number 2, sir. Sir, out there is written that in respondent number 2, that is Genco Enterprises. It is not been represented by the proprietor or the authorized representative. So if I can amend my petition to like and refer it to the
you
director.
file an appropriate application for that.
All right, sir.
All right.
Thank you, sir.
Lordship, he also escapes again.
Why did you?
If Lordship come to page 48, Lordship, Annexure 2. Page 48, Lordship.
No. Why review? It's steps. Service completed.
It's, I think, awaited. Steps are taken on 2 occasions.
Service record in respect of sole respondent is received from CGM senior after duly causing service of notice.
All these are. Kindly see if it can.
27. Okay. Office note. Had Mr. Estafin Lare senior government. Office note dated 14/3/2024 indicates. Reflects that the service report is received back after duly causing service of notice upon the sole respondent. List,
For admission
list
tomorrow.
for admission.
Otherwise, also it can be disposed of also. Very simple issue.
In that case, however, none appears for the respondent, huh?
If lawsuit come to page 48 lawsuit,
48.
page 48. This is the lawsuit order which is sought to be reviewed lawsuit.
Hmm.
Operating portion is page 50 lawsuit.
Yes,
May I read?
50.
5050 lawsuit.
Yes.
Since the appeal prepared by the petitioner is statutory appeal, this writ petition is hereby disposed of at the motion stage itself by directing the Deputy Inspector General of Police, Police Headquarters, Itanagar, to consider and dispose of the appeal prepared by the petitioner, dated so and so against the order of dismissal from service, dated so and so issued by the commanding third IRBN BHQ Sejosa, Pakistan so and so, within a period of 45 days from the date of receipt of a certified a copy of this order with a speaking order. This is the order lawsuit.
Hmm.
If lawsuit turn to a page next lawsuit, this is 51 lawsuit. The appeal prepared by the petitioner, it was already lawsuit considered and disposed of on 26 April 2023 lawsuit. That's prior to passing of the lawsuit order by this honorable court. And this fact was not brought before this honorable court at the time of lawsuit passing this order.
Who has not brought this facts?
Lawsuit
This is of 18.5.
18/5/2023 lawsuit.
Then this
It was 26 April 2023 lawsuit.
where does it indicates that your this application appeal 02011?
If lawsuit see the last order lawsuit, the
So what order should be passed now?
now lawsuit this the order is become in process because prior to passing of this order lawsuit, the application has been already appeal has been already considered and disposed of. Now it has to be closed as lawsuit because order has been passed. Lawsuit. In view of this order passed by the authority in the appeal lawsuit, this order may be reviewed.
Where is this? Where does it indicates the appeal?
Lawsuit, kindly come to page 52 lawsuit 52. Second paragraph from the bottom lawsuit. Therefore, therefore, by virtue of power compulsion and so of rule so and so, do hereby reject the appeal of ex hence Constable Ram Kino and confirm the order of so and so.
Mr. Estafin, learned counsel for the. It's a review.
It's a review lawsuit because this text was not before this one.
Next paragraph. This review petition has been filed on behalf of the state. No, you read it. This petition has been filed. This petition is filed by the state. For seeking review of the order dated 18/05/2023 in the past in WPC 236 of 2023, whereby This court has directed the review petitioner to consider and dispose of the appeal preferred by the petitioner dated 02/11/2022 against the order of dismissal from service dated 03/01/2022. Within a period of 45 days from the date of receipt of the certified copy of the order with its speaking order. Next man. Mr. Estapit Land Counsel for the petitioner. A review petition. Submits that the appeal, statutory appeal, the departmental appeal. It's a departmental appeal.
Yes.
Anyway, the appeal prepared by the petitioner that is 02/11/2022 was disposed of with its speaking order on 26/04/2023 by the Deputy Inspector General of Police within bracket OPS bracket close Arunachal Pradesh. However, when the writ petition was taken up, when the order dated 18/05/2023 passed by this court, passed by this honorable court under review. The said facts could not be placed before this court. Therefore, he submits that in view of the order dated 26/04/2023 passed by the authority, the concerned authority, disposing of the appeal of the petitioner. The direction of this honorable court for disposal, for consideration and disposal of the said appeal of the petitioner has become what do we call it? Become ineffective.
Lordship, that may be closes by review and would liberty to the petitioner because
Could not be,
new course of action has arose. He has a liberty to challenge this.
could not be given effect to. Therefore, as such, the order that it's mentioned under review may be appropriately reviewed. Next. Having considered that the appeal of the departmental appeal of the petitioner dated 02/11/2022 was disposed of on 26/04/2023 before before passing of the order dated 18/05/2023. Passing of the order dated 18/05/2022. I'm of the view that the direction issued for disposal has become Cannot be. Even effective. Listen. On consideration, on the appraisal of the disposal order, that's it, 26/04/2023 by the Deputy Inspector General Police within the office, Arunachal Pradesh, shows that the liberty has been given to the petitioner to file a revision petition in terms of the applicable rules. Does the listen. In view of the no, considering above, liberty is granted to the petitioner to avail the remedy before the appropriate authority. Wisdom. In view of that. Having considered above, the present petition is allowed and disposed of. That's all.
Close.
What it may say the order is recalled and
Is it?
in view of the order passed by the appellate authority.
Okay. In view of the above, before that, before last night, the order dated 18/05/2023. 2023 is hereby recalled.
All right.
If IA is filed by me for what? For modification and alteration of interim order.
Notice has been
Spite
issued.
of last opportunity given by this honorable court in the month of May, till date they have not filed any objection or affidavit.
Yes.
My lord, in fact, was supposed to file the reply. However, my lord, what happened? Meantime, the father of the petitioner was passed away, my lord. So, due to domestic reason, my lord, now I've been informed that he went to his native village also.
Who passed away?
Father of the petitioner, my lord.
Father of the
Petitioner,
petitioner.
my lord.
Otherwise, it's ready.
My lord, almost it's ready, my lord.
If it is ready, we'll take note of it,
My lord.
even if you are filing also. If that is the ground. Is it ready?
No, not with me right now, my lord.
So next week in that case, if it's a,
Difficulty is that my lord, by taking advantage of the
what is the interim order?
interim order, my lord, they have stayed the eviction order.
Who are you?
Actually, I am the government quarter allotee,
Okay,
and he is occupied my courtyard,
encroacher.
encroacher, and now he taking advantage of
You want that
interim order.
it should be removed.
Yes, by taking advantage of interim order, they are trying to erect a permanent structure.
Next week, we'll dispose of the matter,
My
entire
lord,
matter.
after 2 weeks, my lord.
No,
2
no,
weeks.
my lord, it's already very.
And my lord,
First,
otherwise, my lord, in
Are
his-
you, do you have any allotment order?
No, my lord.
Then. Or we'll dispose of today.
My lord, next week, my lord.
We'll not vacate this, we'll dispose of the writ petition.
My lord, actually, we are yet to file our reply in the main case also.
What reply? It's a government land
Yes, Lord, sir.
in front of the quarter
My
or
lord,
a back side or left side or right side.
Front side, my lord.
Huh?
Front
Side.
side, my courtyard.
Tomorrow.
my
Will
lord,
they dispose of entire matter?
next week, my lord, next week, my lord.
You don't have to file reply also. We'll not look into their affidavit also. will dispose of on your on your pleadings only. All right.
Otherwise, we have applied line allotment.
What's there? Therefore, yesterday I passed and this court has issued passed an order. Just because you are occupying the government land, you don't have an independent right. Let us give him 1 week chance so that
My lord, the fixed date may be given, my lord.
wisdom.
2 weeks at least, my lord.
My lord, for last about 10 months, they are not filing reply to my
Doesn't make a
application.
difference.
Well, because I have to take instruction from the petitioner also.
Take instruction, we're giving you 1 week. Yes, heard Mr. El Kurdu, Land Council for the petition. And also heard Mr. Who is one? Who is two? Who is respondent number one? Mr. D. Kamduk so for respondent 1 and 2. G at for respondent number. Then
Three and
senior,
four.
additional senior government 3 and 4. Mr. D. Laj and Mr. D. 4, respondent number 5.
Yes, my lord.
Okay. Matter relates to eviction. List of considering the nature of the issue involved. Come on. Let this matter be listed after a week for final disposal. You think about for 1 year or 1 week.
My lord. Obliged, my lord.
Most of them.
Continue, person. Okay, there are so many orders. Affidavit.
When respondent
No,
number
no,
two is yet to file.
Malad, I don't know Malad, how the affidavit would be required in this matter. Malad. This is an order passed under section 140 of CRPC, wrongly or rightly. Malad. As an executive magistrate, Malad, I don't know what affidavit would come from there. How even party has been made to the additional deputy commissioner.
You are?
I'm for the respondent number 3, Malad.
3.
Yeah. Otherwise, the matter is very small, man.
Yes.
If not, Your Honor, a date may be fixed for disposing the matter. A date may be
Yes.
fixed for disposing the matter, Your Honor, because it's been pending for quite a while now.
Brothers.
Brothers.
What of your
Yes,
brothers?
yes, sir. Real brothers,
What is
man.
the problem?
We are challenging the order passed by the ADC in this particular WPC
Then what's wrong with the order?
because the ADC Kamba had passed this order as though it is exercising its civil jurisdiction, which is not permissible under after the enactment of the Arunachal Pradesh Civil
It's a
Courts
dispute
Act.
about the title.
About the
Dispute
title.
about the land.
Yes, so the ADC had passed
Settle.
Malad,
interim
that's-
order.
Settle between the parties. Brothers.
Yes,
Real
real,
brother.
that's a real
Or
brothers.
step brothers.
Real brothers.
Then settle it.
Otherwise,
Because in the event, if we pass, maybe this way, that way, may affect the relation. Tomorrow.
what we are submitting, this matter, though the application was filed under section 145 of CRPC, the order has been passed, rightly or wrongly, if the additional deputy commissioner might not have followed the procedure laid by the CRPC, in that, even in such a situation, the petitioner can approach this session judge in a revision, not before this honorable court.
What is this? Let's see.
Let
The
the
order is expressly
if you-
legal, Your Honor, that is why.
Yes.
It's at page number 20.
20.
Yes, Your Honor.
We're granting you some time to settle amicably.
Otherwise,
Your Honor.
the requirement of additional ADC filing affidavit is not at all
Yes,
required,
it's not
I don't know.
No, even if we do end up settling the
Split it into
matter,
parts. Yes.
even if we do end up settling the matter, the order itself, it stands illegal, Your Honor. So
You
it has
come,
to be
will
quashed.
appropriately pass the order. You settle past, then we appropriately come. Real brothers.
Because there's there is an appeal which is already pending before this
You'll-
honorable court
You'll
with
miss,
regard to the same issue. So
you'll miss I mean, both of you.
My lord, what interesting,
At the
my lord,
end
the,
of
the fight was with the third party, my lord.
In
not
the
the
late
appeal.
evening of their life, you will realize how you have, why you have fought for a thing with the brothers. Considering the nature of heard MS so-and-so, and MS so-and-so, KO, and Mr. Peter for respond number 3.
Yes.
Next paragraph. Considering the nature of the issue involved on merit, comma. The learned counsel for the parties are granted 3 weeks' time to make an endeavor to settle the issue on merit between them.
Yes.
Parties, as it is reported, it is stated that a petitioner and a respondent number 3 are real brothers.
Yes.
List after 3 weeks.
Yes. Obviously.
We'll resume at 2.
Yes.
By the earlier order dated 22/7. This court directed the respondents to process the bill and pass unnecessary order. That has not been done as yet, my lord. Otherwise, pleadings are complete. Matter can be heard.
Where is this order?
Order dated 22/7/24.
22/7.
7.
24.
24. They have done the joint verification of the, they have done the joint verification, they have measured the unpaid work. They have submitted the report also. And to that extent, I have submitted my bill. So that has not been processed. So therefore, this order has been passed, directing them to process the bill submitted by me and pass necessary order on that. So they have not done as yet.
Well, confirm in that case. If that is done,
My lord?
it's over.
No, then the question would whether it will be paid to, because they are claiming what they are saying as per the contract agreement entered between the BRO and the respondent number 6. This is the principal contractor. They have to pay the amount to the principal contractor.
Whatever the any arbitration clause.
My lord, so far as I am concerned, I don't have any agreement with the respondent.
Okay, you are third. I mean, what do you call it? What contract?
I have executed as a subcontractor.
Subcontractor.
And I don't have a subcontract agreement with the respondent number 6 also, principal contractor.
You cannot have grievance against the authorities.
No, my grievance is that since I have executed the work,
You want they should
they have received the work, so the payment should be paid to me. And in their report,
admission hearing.
My lord,
We'll list it for admission hearing.
admission hearing, my lord.
Pleadings completed.
Pleadings complete, my lord.
If they have not act upon the orders, you may rebel the rebel.
That would be convenient for this court also to finally, my lord, passing the order, my lord, the amount what would be admitted.
Mr. PJ Sekia, senior counsel assisted by so learned counsel for the petitioner. Yes.
Here, Your Lordship, I'm for respondent number 5, Deputy Commissioner. We have not filed our contract affidavit, Your Lordship.
What is your role?
We have not received also, Your Lordship.
What is your role?
My role is your
What you are
lordship.
supposed to do? Respondent number?
5, your lordship, deputy commissioner,
Yeah, just formal party.
formal party, your lordship.
Otherwise, it is submitted that the pleadings are completed. Pleadings are complete. Come on, list for admission. After when?
Sir, I'm appearing to respond, pro forma respond number 7. My appearance just may be marked.
In that case, also heard Mr. So and so. Your name, please?
A. Sandilya, my lord. A. Sandilya.
And Mr. M. for M. Kato, learned BSJ and P. Pang. Then you write that it is submitted that the pleadings are complete. List for admission here.
If next week or my lord, Monday next, my lord, any convenient date.
After 2 weeks.
2 weeks.
After 2 weeks.
Can there be, my lord, I'm praying for 16th if possible. 16th. Interim order passed earlier, may continue.
Interim order first, earlier shall continue. Yes.
But can there be further observation? In the meantime, they may also, my lord, file the, pass the order, necessary order as directed by the order.
We'll see. If the first order is not been complied with, well, I don't know. It's okay.
May I please, your lordship?
Yes.
My lord, this contempt petition pertains to, my lord, violation of order dated 30/1/2024 by which, my lord, the respondent authorities, my lord, particularly.
Service completed.
It's complete, my lord.
Service complete.
My lord, insofar as the respondents are concerned, my lord, except respondent number 1 and 2, my lord, the other respondents, my lord, name of the other respondents, my lord, stand deleted, my lord, in view of the order dated, my lord, 27/06/2024, my lord. My lord, respondent number 1 has come with an affidavit, my lord.
Yes.
Seeking further 3 months time.
Here.
Yeah, my lord.
Will grant.
My lord,
Will grant 4 months time.
stressing the, my lord, timeline too far, my lord.
Will modify the order.
Like, my lord. Some sort date may be given, my lord. For,
Which appearing? For respondent number 1. Who is respondent number 1?
respondent number 1 is Kato was appearing. Kato,
Ankush. They are seeking for a time extension of
3 months
Why they are
extension,
not filing
further
it?
to use. My lord, it is almost 8 months, my lord, since the order.
List after a week. Heard Mr. Raba.
My lord.
S. Raba.
Yes, sir.
S.R. Raba.
Well.
Counsel for petition. Not appears for the respondents. It is noticed that the respondent number 1 has done an affidavit on this matter. List after 2 weeks.
1 week maybe, my lord.
List after 2 weeks for further consideration.
Obliged.
May I please, my lord. My lord, as per file noting,
Await
service
service
report is awaited. May I
Await
pray, my lord, I may be allowed to take a
Heard.
fresh step as well as to justice service.
Heard the legislative council for the petition. Next where office note dated 04/09/24 reflects that service report in response number 1 is still awaited. Next para. Mr. D. Laji is permitted to take fresh steps.
Yes. And justice service also.
Notice upon response number 4. As well as let's through the steamboat.
Yes, ma'am, justice also.
By regular process as well as the steamboat. Within 2 days.
Most obliged.
Yes.
My lord, in view of the subsequent development that the tender, technical bid was, financial bid was also open, my lord. In this IA, we are praying to make necessary amendment, my lord.
Okay.
In the para 7, my lord, we have want to make the one add, my lord, these two paras 19A and 19B.
19A and 19B.
Yes, and in prayer, my lord, we want to add prayer, my lord, the challenging the financial opening dated 28 2024. Right.
Yes, any objection? No.
No, there is subsequent development here. In it.
Heard Mr. Peter Land Counsel for the petition, applicant, public petitioner, and also heard Mr. Jitara, Land Standing Counsel for Land Standing Counsel, RWT, appearing for under respond appearing for opposite party respondents, opposite parties respondents. While they filing this application, the applicant has sought for amendment of the writ petition being the WPC amendment of WPC number what?
344.
344 of 2024.
Yes.
It is submitted that in view of the subsequent developments during the pendency of the writ petition 34.
Yes.
344.
344.
344
Yes.
of 2024. Come on. The applicant has prayed for amendment of the writ petition by incorporating the following paragraphs as 19A and 19B.
Yes.
Which are produced here in, which are reproduced here in below, which are quoted here in below. Quoted as under. Page 7, huh?
Yeah.
Last, what did I say? Last sentence. Before that. Incorporating 19A and 19B. Which are quoted as under, huh? Page 7. And also, and next paragraph. It is further submitted that the prayers person may also be allowed, which is as under, para 8, huh? Having the Mr. Jitara, Standing Counsel, has raised no objection to such prayer for amendment. Mr. Next one, having considered the grounds taken for amendment and the prayer being not opposed by the land counsel to the response, I deem it appropriate to allow this application by allowing the applicant to amend the writ petition, amend the WPC 344 of 2024, incorporating paragraph, incorporating 3 paragraphs as 19(1)(a), 19(b), and also in the period portion is Roman 4. Huh?
Yes.
The application stands is allowed in disposal.
Yes. Main
In view of the order passed in so and so. So and so. In the main, in view of the order passed in IA so and so so and so. The petitioner, the learned counsel to the petitioner is directed to file consolidated
Yes, Lord. We'll file.
amended petition within 2 days. Within 2 days, 3 days.
My lord, within 3 days.
Within 3 days.
So tomorrow is Friday last.
List after. Have you filed affidavit? No, you will have to.
Yes. My lord,
Then-
for affidavit, already 2 weeks notice was already issued.
Okay, then list after
1 week, my lord, tender matter, we want to finish it off.
2 weeks, 2 weeks.
Yeah. Maladin, we wanted to take dusty service on respondent number 6, my lord.
You file, then you take.
Dusty.
First you file.
Yes, yes, obliged.
What is the matter?
28, 29, 30, supposed to be a connected matter, my lord.
28, 29, 30.
30, my lord.
Yes.
29, my lord.
Yes.
There is an interim order, my lord.
Item 28 and 30 are, my lord, after writ petition, after filing our
29.
IA, my lord, thereafter they have filed these 2 writ petitions, my lord. In item number 29, we are the respondents, my lord. There is an interim order, my lord,
Yes.
for which we have filed, my lord, vacation application. My lord.
Yes.
It is IA 1128 of 2024, my lord. In WPC 166 2004, my lord. My lord, the IA was taken up for consideration on 2 occasions, my lord,
Yes.
but could not be disposed of, my lord. And fixed the matter for, my lord, 8/8/2024 for consideration, and again on, my lord, 29/8/2024 for consideration, my lord.
Yes.
But it could not be, my lord, considered, my lord, and the pleadings are complete here, my lord. My lord, in the web, lordship has, my lord, passed an interim order dated 10/4/2024. Lordship, my lord, kindly take up my IA, my lord. 1 KL, my lord.
Just wait. Yes.
My lord, I filed this IA for vacation of your, my lord's order dated 10/4/2024. Lordship will
10/4.
find at page 51, my lord.
10/4.
10/4/2024, my lord. Page 51 in my IA, my lord. In the writ petition, basic challenge was made.
Page.
Page 51, my lord.
Okay.
May I read, my lord?
Yes, this court, after hearing the parties, directed the state to file an affidavit.
Yes, madam. And they state has filed affidavit also, madam.
They filed the affidavit.
Yes, madam.
Yes.
My lord, my
grievance at this stage is, my lord.
Yes,
May I read the entire order, my lord?
yes, yes.
Page 51, my lord. Challenge made in this writ petition is the notification dated 22/1/2024 by which the seniority list of statistical investigator has been finalized under the Department of Economics and Statistics, Government of Arunachal Pradesh, whereby the private respondent number 5 to 13 with the applicants, my lord, here have been placed as serial number 13 to 21 above the petitioner. It is contended by the learned counsel for petitioners the respondent number 5 to 13 were appointed divorced the rules as there was no selection process for appointment of the respondent number 5 to 13, whereas the petitioners were appointed statistical investigator after proper selection process pursuant to advertisement dated 5/2/2021, and they were appointed in the year 2021, madam. Issue notice returnable since the my lord may escape, madam. Then case 52, last paragraph. Considering the prima facie private respondent 5 to 13 have been appointed divorce the rule, the impugned finals gradation list dated 22/1/2024, placing the private respondents 5 to 13 above the petitioner shall not be given effect to, and no further promotion be given on the basis of the impugned final seniority list to the next higher post of statistical officer under the Department of Economic Statistics for Government of Arunachal Pradesh till final disposal of this writ petition, madam.
Yes.
My lord, it is debatable, my lord, as regards to the, my lord.
Appointment.
No, my lord, the fixation of the seniority, finance seniority list, my lord.
Yes.
But my lord has state further promotion from this statistical investigator to statistical officer, my lord. My lord, in the writ petition, there is nothing on pleading that, my lord, about the recruitment rules of the promotional post, that is statistical officer, and whether they are qualified for the promotional post or not, my lord. It is purely silent, my lord. And prayer is also nothing in sort of, my lord, seeking a stay of further promotion. Only in the interim they have sought this prayer, my lord. My lord, my submission is that, my lord, I have annexed all the things, my lord.
But what is the challenge here?
Challenge is the seniority list, my lord.
Appointment also.
Appointment is not in this writ petition, my
In
lord.
this writ petition, yes.
Huh?
Yes.
Yes.
Yes. The appointment itself is under challenge.
Let's see, my lord. To my respectful submission, my lord, no, my lord.
There is.
Because in the subsequent writ petition,
No,
they have challenged, my lord.
It is there.
Let's read, my lord. I will read, my lord.
Page 32C.
But here it's a sweeping prayer, madam. Call for the records pertaining to appointment of.
Why subsequent writ petitions?
Subsequent writ
There
petitions.
are other persons.
There are two
Same persons, madam.
No, man. Two persons who were promoted in the meantime, that has been put to challenge in 266. And when this IA was filed, we came to know that they were regularized, my lord, on the recommendation of a selection committee. I think very interesting, my lord. They were appointed just before the earlier advertisement, around a month back. Advertisement done after 1 month, they were regularized. In fact, they, in their own admission, they also applied in the earlier advertisement.
Yes. In this petition.
So, as a matter
In
of
this petition.
no, my lord. As a matter of abundant caution, my lord, we have put to challenge the recommendation of the selection committee also in 365.
365.
Yes. There, everything is under challenge.
But different petitioners. Same petitioner.
Same petitioner, same respondents, madam.
Okay.
Second writ petition, because there was 2 promotions already met, so there that has been put to challenge.
Yes.
Third, my lord, the recommendation of a selection committee for regularization also is under challenge.
My lord, in this IA, my lord, I am seeking modification of this order, my lord.
Yes.
As because the writ petitioners are not eligible in terms of the rule for promotion to the next higher promotion post of statistical officer, my lord. Recruitment rule requires, my lord, 5 years of regular service in the feeder category. And they were appointed in the year of 2021, and they will be completing the 5 years of regular service in the year 2026, madam. And my ground for claiming, my lord, for vacation of this modification of this order is that, my lord, on the basis of NR Banerjee, my lord, whereby it says, my lord, the authority has to, my lord, prepare a year-wise vacancy and prepare a select list, and every year, every vacancy should be filled up every year, madam. And pursuant to the NR Banerjee's judgment, my lord, Government of India has issued a notification, my lord,
applying those ratios, my lord. And accordingly, the state government has also adopted the memorandum, my lord. And accordingly, separate memorandums, various separate memorandums were issued, my lord, directing the respondent departments, respective departments, to prepare the, my lord, year-wise vacancies, my lord, and the panel for promotion. And DP has to be constituted every year, my lord, for building out those sanctions, my lord. And by now, my lord, I have annexed those also, my lord. There are 11 vacancies, my lord, for promotion. Only because of this, process was also started, only because of the stay of this, by this honorable court, the DPC could not be held, my lord. My only submission at this stage, my lord, let the DPC be held, my lord, and our promotion may be subject to outcome of the repetition, my lord. Because though it is legality has been, my lord, put to challenge in another repetition, though it may be after thought repetition, my lord, that will be finally decided by this honorable court. By now, there is no stay of our initial appointment and the selection committee, minus of the selection.
We'll stay today.
Without hearing, my lord,
We'll hear you.
no, madam, we have not received any notice in those repetitions.
Those repetition.
Yes, ma'am.
You have not.
We have not received any.
266, the respondent by learned senior represents are not a party. But in 365, they are a party, all of them.
But problem is you are not eligible.
That is another thing, my lord. Their appointment itself is under challenge. And your lordship has been private officer satisfied their initial appointment itself is illegal. That is why this interim order, my lord. So now if your lordship vacates this order, what will happen? Their appointment, regulation itself, their appointment itself is under challenge. So they will be allowed to be promoted. Then thereafter, my lord, will be agitating again, my lord. How can that be allowed, my lord?
We will reply
When-
to those repetitions, my lord.
When, my lord,
My lord,
In that case, will allow since you are not eligible,
Yes.
admittedly, will allow the promotion and will pass an order in the event,
yes,
if the writ petition is allowed,
yes.
they have to refund all the benefits which they have.
And then they will have to go out of the job also.
Yes.
My lord will make that
No,
clear because
obviously, if you have
because if
challenge-
there is a promotion
see,
now,
if you-
I
if
will
you-
have
if
to
you- if you
I
have-
will have to challenge the promotion also, my lord.
If you have, if their appointments are under challenge,
Yes.
obviously we'll consider. If we find that this was
But
appointment
madam-
was illegal, they have to go.
Yes, prima facie they are illegal, my
And-
lord. If your
and-
lordship
and
now allows
And
them,
we'll say that we'll not consider that they'll have to refund everything to the.
then my lord, how can they be allowed to be
in the
promoted? my lord?
event, my lord, we are.
I will
unsuccessful
reply, my lord.
in those
Yes.
repetitions. In the event that we are unsuccessful in those repetitions, then only my lord, it can be recovered. My lord, first, my lord would not have. passed those-
From the date of appointment, all benefits you will have to refund.
So that will be decided in due course of time. my lord.
No, that will make it clear. In the
Yes,
event
my lord.
writ petition is
My
allowed,
lord would not have passed the interim order if, my lord, they put in the meetings that, my lord, the factual aspects, my lord, regarding the recruitment rules and their eligibility. my lord. Then, my lord would not have stayed, my lord, the DPC, my lord. My lord would not
My
have
lord,
stayed, my lord.
no, this
Yes,
is,
they-
this court.
I will be
has-
allowed to.
This court has passed this order because in view of because there's a prima facie finding that your appointment is deholds the rule on the basis of the submission and pleadings. That's why it has to be.
Yes, my lord. Because for promotions, my
Because
lord,
if your appointment is illegal,
that has to be determined.
yes,
after
that is
all the parties
prima
decide.
facie, we found that it was deholds the rule.
My lord, the
So
best
you
course of
don't have-
action would be, my lord, let them reply to the other petitions also. 2 weeks, let it be disposed, my lord. 10 days also, I have no issues. What is the point, my lord,
Yes,
allowing
what-
them to be promoted now?
Yes, what
Then
is
I will
the-
have to challenge, put them to challenge, my
yes,
lord.
what
But
is
it is
the-
allowing some
what is
illegality.
the state of the state?
Sorry, no.
Yes,
My lord, in fact, the documents,
just wait, you are directed to file the affidavit.
yes, we have filed, my lord.
What is your stand?
Out then, my lord, regarding that.
Appointment.
Appointment. Appointment, not they have been regularized subsequently.
How?
By way of a DPC, my lord.
What is the
Because-
appointment?
Appointment,
Initial appointment, how it was taken?
yeah, appointment, it was because they have applied and they were continuing.
Is it permissible?
Exactly, my lord.
Well, I will
Wha-
just
what
clarify
our-
one
what-
thing, my
what
lord.
Ours,
We are
Just-
appointed,
just-
my
just
lord,
with it.
against the centrally sponsored scheme initial.
Maybe.
yes, my lord.
Was there
regarding-
any policy decision in consonance with the rules?
My lord,
There's no policy decision also.
to that, my lord, as it is not their initial appointment is not as per the rules, that is it. But, my lord, here, they have been regularized earlier, my lord. That regularization or their contract appointment whatsoever, that was never challenged by the petitioner at that point of time.
Oh,
That was never challenged. Their appointment, their continuation, and that regularization. What after the seniority dispute has come, then they have realized that
That technically.
We have not realized.
Just wait. Technically, which we will consider, but in fact remains that their initial appointment is
yes, madam.
not in
Yes.
accordance with the rules.
Yes, that is there.
So if foundation is removed,
Madam, for that, there is
not only structure, superstructure falls.
madam, there is delay in nature on the part of the petitioners, madam. Even while these respondents were functioning, had they been eligible at that point of time, they could have challenged it, madam. They did not. The regularization.
That is technical aspect.
No, I mean, my lord, kindly allow me to reply to that, madam.
Today is listed for modification or vacation of the interim order.
delay in latches, my lord.
Sir, I think we'll go for
Delay
the
and latches,
disposal,
my lord.
final disposal, because on their submission also, it appears your appointment was deferred the rules.
By their
Of
own
course,
admission.
We will consider that. We'll fix
Definitely, my
the letter better for, because as of now, we accept that they are not eligible. But then if your appointment is under cloud and until we decide it, it would not be proper to go for further promotion.
Let it be within around 10 days, my lord. I'm ready.
You file affidavit in those cases also. Whatever they state.
No, I can say, but it is the client will approve the matter. Whether they have to-
Same person, same petitioner. That's why I'm asking,
Yes,
it's the same petitioner.
Same parties also, respondents.
If
also.
in
Whether they have taken step and.
Oh, I
No,
have taken a
let us
step.
do one thing. Instead of modifying it, we'll dispose it of, consider the entire matter on
Next day.
after 10 days, we'll consider it. And we'll keep it pending in case if the repetition is not disposed of. In the event, if it
360
cannot be taken up for final disposal.
Yeah.
Your the ISL be considered on the next day.
365, my lord, we have filed as a matter of abundant caution. If they want to reply, they can reply. If they don't want to.
No, if that is the other thing, and if the basic challenge here is the appointment and
Appointment itself.
seniority, we'll consider even if there is no affidavit is filed
Yes, that can be.
in other cases.
Yes. Only difficulty is the two persons, they are not responding. 266, that is a difficult. But otherwise, if your lordship permits, I will take dusty on them. These two.
In
266.
item
266, item number 28.
260.
These are the two persons who have been promoted. So that by the next day, they can also, they are aware of these cases. Five and 6, Bijum Bogo and Noah Jugli. 266, madam.
Okay.
Item 28.
In IA. Right. Mr. Arsik, learned counsel for the applicants, public private respondents, applicants. And also heard Mr. Deepang, learned counsel for the opposite party. petitioners and the and Mr. N. Ratan, counsel for another additional advocate general for the state. Should I record why it has to be adjourned? Otherwise, it may have a problem on next date. We'll say that in view since the pleadings are completed in the writ petition so and so, main petition, let the matter be listed for admission hearing. The endeavor shall be made to dispose of. In the event, in case the writ petition is not taken up for final disposal on the next date, we'll consider the IA. We'll consider IA. IA. Considering that the pleadings are completed in the main writ petition.
My lord, in 166, my lord, I will file reply, my lord.
166. It's not
Affidavit
completed.
affidavit in reply. This was filed only last day and the insisted on my learned senior, my lord. This was fixed today, my lord.
Yeah.
We didn't get time.
On 29, whether they so file to file.
Since the affidavits have been filed, affidavits have been filed,
But there's a very short time.
affidavit oppositions have been filed in the main writ petition number 166 AP 2024. I deem it appropriate to list the matter for admission hearing instead of dispose. I deem it appropriate to list the list all the matters. List the matter along with the main writ petition 166, WPC 166 AP 2024 for admission hearing. Listen. Next paragraph. In the event the main writ petition is not taken up for final disposal. Before that, on the next day, the main writ petition, on the next date, WPC 166 AP 2024. In the next date, an endeavor shall be made to dispose of the WPC 166 AP 2024 list of. In the event, next para. Not in the event. In case if the main writ petition is not taken up for final disposal, the present IA shall be taken up for consideration on the next date. List after 10 days when in IA, in writ petition. That is in the IA. In writ petition 166, parties have, the respondents have filed their contrary affidavits. Mr. Deepak, counsel for the petition, is granted 10 days time to file affidavit in reply. It's 266.
Yes.
166.
266, respondent number 5 and 6. My lord is fixing this on, my lord.
You choose the
Next week I have difficulties.
Okay. It'll be on 25th, on the 18 by
18 does not come 10 days. Next week I have difficulties.
25, 26.
It will be after 19.
26. 24, 25,
24, my lord.
24.
24.
List the matter on 2409. Then in 266,
My
we have to
lord,
take steps.
yes, upon, we have already taken steps. Just to facilitate the hearing of this case, my lord, I'm making this prayer. I'm not
Yes.
required to actually.
List-
5 and 6, I will take Dusty.
Mr. You are not representing 5 and 6.
And I have to get instruction from.
Okay,
the-
okay.
I can so moto appear for them now.
In
Yeah,
266, huh?
Mm.
List this, the, Mr. Deepang, land counsel for the petitioner is permitted to take steps upon respondent number 5 and 6.
5 and 6, yes.
5 and 6 by Dusty Moore within 2 days. Within 2 days.
And
List
in
the matter along with 166 AP 2024. And other one?
365 also, my lord, here no. Notice was issued only on 29.
This is what?
This, my lord, the recommendation of the selection committee, their initial appointment, all are under challenge.
You have not taken steps.
We have taken steps today.
Okay, in that case, you may take Dusty also. We will permit you to take
Dusty also here.
Extra copy also, my lord.
Yes, yes, we have furnished today.
Heard Mr. Deepang Land Counsel for the petition. And also heard Mr. N. Ratan Learned Additional Advocate General, Mr. Office note dated 04/09/2021 reflects that steps have not been taken by the petitioner. Mr. However, today, Mr. Deepang submits that the steps have been taken today. And he has taken the steps today for service of notice upon the response 5 to 50. Since the analogous matters being WPC 166 and WPC 266 are listed for admission hearing on 24/09/2024. The petitioners to take steps by Dusty Mode
5 to 15.
for service to upon Dusty Mode upon respondent 5 to 15 within 2 days. List along with
3 days, my lord.
within 3 days. List along with list this matter along with 166, huh?
266. Demlad.
May I please, your lordship.
Yes.
Issue in this case is, lordship, the petitioner's father had allowed the department to construct a temporary MIT building, PHC, which was run as PHC subcenter. When after many years, so many prayers were made to vacate the place, but it was not done. But when ultimately they had tried to build a permanent structure, the petitioner protested. By the time the petitioner's father had expired, petitioner protested, and instead of stopping that construction, the government had instead given the title to themselves of the land. That is the case. Now we are saying that you kindly pay compensation or otherwise shift from the place. On query from this court, that whether that place has been shifted, I think government advocate was asked to bring some instructions. I was told that they were deciding to shift from there.
Not shifted.
Not shifted, your lordship.
But I'm told that there is a proposal. That of course they'll be knowing.
Yes.
Your lordship, this one regarding this, your lordship, we have taken the information, your lordship. that informed that public health center at village Patum Jomlo Monku under Rumgom subdivision is still in existence and has not shifted to different location plot of the land and is still in functioning from its said premises at Patum, Your Lordship.
It's in Patum village.
Yes. It's called
Village- village
Jomlo Monku village. The place area is known as Patu Domong.
Is it just Patum Domong?
Patu Domong.
Patum Domong is what?
I don't know. It's the name of the place, I think.
It is with the health center at village Patum, Jomlo Mabu, under room.
Jomlo Monku village.
Monku, huh?
Yes.
They are saying village Patum, Domong, Jomlo Monku.
Domong. The place is called Domong area.
So what is the state of the respondents?
The respondents, Lordship,
Where is the impugned order?
impugned order is page 28
28.
or 29, sorry.
It will be 28.
29,
28.
Lordship.
There's two page,
Oh.
page numbers.
Oh, sorry, Lord.
It's 28.
4/8/2017. May I read, Lordship?
Yes.
Heard the complainant Sri Kaling Saro on the matter of illegal construction by Sri Tapir Tamut on his land at Domong area. Sri Kaling Saro apprised that undersigned that area over which is given the complaint of illegal structure construction is the medical area PHE at Domong, which had belonged to his father, Sri Tanong Saro. He further stated that since he being the landowner at PHC Domong, he need to be compensated by the medical department, and he had filed a complaint against Sri Tapir Tamut, who was awarded contract for construction of boundary fence at PHC at Domong by that medical department. The complainant, in support of his claim of being a landowner, had enclosed the copy of the Kabang decision dated 19/3/1996 and Kabang decision number dated 3/6/1997, along with certificate given by the PRIs and the GB of Jomlo Monku of him being the landowner at PHC at Domong. Heard the respondent Sri Tapir Tamut, he stated that he had constructed the boundary fence of PHC since he was assigned the work by the medical department. The MO in charge of PHC taking in on the matter apprised both the parties that the complainant may be the landowner, but since the land was donated to the medical department, it's lookout of the medical department to ensure the safety of the PHC and so the boundary fence construction was done and the work was given to Sri Tapir Tamut. Heard both the parties, and after going all through the documents available, it is seen that the PHC area at Domong was donated by Sri Tanong Saro, father of Kaling Saro, but there is also clear mention in the Kabang decision that the donor cannot claim upon the land donated on the PHC, but if in case the PHC shifts from the present location at Domong, then Sri Tanong Saro can claim his land. Therefore, since the area has been donated by the PHC, the medical department has given the work for construction of boundary fence of PHC to Tapir Tamut, and allegation against Tapir Tamut of illegal construction by the complainant Sri Kaling Saro is unfound. They have said that it was done on donation, although there is no such record. There is only a mention of a Kabang decision, which we have also annexed. In the Kabang decision, actually what happened was, although there was no formal.
There's no affidavit.
No, sir?
There's no affidavit.
Affidavit?
Yes, where is that Keba decision?
Keba decision, Lordship. that 1996,
96 or 97? Both.
1996 Lordship, page 15 and 16.
15 and 16.
Annexure 3.
Yes.
15 is in Adi.
16 is
16 is a translated copy. What happened was that one Taling Jonnom had encroached upon that land, and that is why the father of the petitioner, Tanong Saro, had made a complaint, and hence this Kabang was held.
Yes.
From the paragraph 2 in the Kabang decision, it is said, therefore it is also decided by the PI and GAM that Sri Taling Jonnom shall not create any disturbance on Patum Domong area of Sri Tanong Saro, and in case in future people who are residing in Domong area RWD unit unit hospital is left, then no one shall have the right to come to Patum Domong area. Sri Tanong Saro shall claim that area by himself. Although that
What does it mean? Tanum shall not create any disturbance. Area of Tanung Saro, and in case
what happened is this, in that place, Taling,
left place, then no one shall be there. Yes.
Lordship, I admit,
If they are if
if they
are
shift,
still there,
yes,
so
they are saying that they have donated the land. There is no such record. There is no formal donation, but we have allowed to stay.
your father is allowed.
Yes,
Is
my
it alive?
father is allowed,
Your
and
father is alive still.
he is expired. He is expired, but thereafter, Lordship, we had met several representations. One being
Let his soul be rest in peace.
government cannot simply take.
Since he has allowed.
Lordship,
And it is for public, it's not to anybody. It's a
Lordship, page
PHC,
18, page 18.
Primary Health Center.
Yes,
It's
Lordship.
for all the people in the area.
Lordship, even when the father was.
Will pass an order saying that will direct them to recognize your.
They'll have to pay compensation then, Lordship, if they're not shifting.
donation.
Lordship, may see page 18. This is the complaint made by the father. Page 18. This is a complaint to the Director Health Service. This is by Tanong Saro, the father of the petitioner.
Yeah.
Complaint against repairing of health sub-center at Domong on my own land area. Most respectfully, I would like to lay drawn a matter in favor of early action. That, sir, I have already developed horticultural land in this area since 1986-87, but with request of Sri Tamar Darong, ex-ASM Jomlo Monko, I allowed him for temporary construction of sub-center. Therefore, I highly request you to stop the repairing of a sub-center Domong area in my own land. This was the objection made by the father, saying that I have allowed for only temporary construction. Thereafter, we had also, okay, if you're not vacating the place, at least give us some appointment of my wife as in the job, in the department. That also was not given, but of course, that is not that we can pray for it. Then, Lordship, at page 21, I have said kindly vacate the place because you have not done any proper land acquisition. Page 21.
Yes.
Madam, the land in question, madam, it is whether it is donated or not, that is not dispute. It is a donated land. It is also admitted by the petitioner himself. In the reading and as well as document about this admitted fact that it is donated. So far, madam, even in view the order they relying in subsequent and the earlier case also before doing that of the 2017, there was the Keva decision, series of Keva decision that
97 or 17?
Madam, Their challenge is 17, and prior to that, there's also two Keva petition already, wherein.
But then his title, his father's title is established.
My lord.
Only that he has allowed you to allow the land to use.
My lord, donated part, my lord, even their writ petition at page 22, my lord. It is admitted this land has been donated. Page 22 of the application of the present petitioner, man. The first man, I have donated the Danong land for construction.
That's a
of
primary health
health.
center.
Yes, ma'am. Said land was donated to medical department with verbal, my lord. My lord.
Put my version, sure, against it.
So for the donation part, my lord, it is admitted, my lord. Now, at page 3 of my affidavit of opposition, my lord, filed by respondent 3, 4, 6. Now we have categorically stated this land, my lord. This was donated by the community, my lord. The region of the Jumlo Mungo, my lord, in 1990.
Then your stand would be contradictory. Either he has donated it or
my lord, he has donated, my lord, it's not a, he's also part, my lord. I'm not saying that he is not, but this is donated jointly, my lord. But the people of, he's also from that, my lord, that same.
You are not disputing the honor of the
Well,
ownership.
donation part is we are not disputing.
Ownership also you are not disputing.
Ownership part is
If you-
has been donated, man.
Unless you are the owner, how can you donate it?
My lord, the donation part, they are also the one of the member of the Jolu community, my lord. The petition, he's also the one of the member. Now this has been donated for the public utility, public purpose for the establishment in year 1998.
Yes.
Now, and earlier Keva decision also, my lord.
Only other. It's
Earlier
over.
Keva decision at page
It's
11.
over. Go get it done. You send Yabu or Yama. Yes.
Page 11, my lord. There also from Keva decision, my lord, it is still confirmed that land was donated by the community. Lot of land around the medical sub-center Danun was illegally occupied by Showman. Thus, he constructed hard control. Since this plot of land was donated by the community of Jongluju.
This is which Keba?
This is of 2004. Third line, hence meeting held on 7th March 2004. Meeting eventually decided no private shall be allowed to construct any house for the purpose of, as it belongs to the community and donated for medical purpose.
Is he a signatory here?
My lord,
Was it a
It's
part
a
of the
people
Keba?
matter.
Yes.
and my lord, one member Talong Taling Janong. Taling Janong name is there, Janong.
No,
Seven.
who is the petitioner?
Malo, the petitioner's name, Malo, the here also, Malo.
Taling Saro.
We have no knowledge of this, Lordship.
Now, Malo, why I'm referring this, Malo? Serial number 8, 9, Taling Janong. Now, the affidavit of.
You was the one who had contested.
My lord.
I mean, you are the first who has complained against the petitioner's father.
My lord. Now, at page, my lord, we'll see page 17 of the affidavit of opposition filed by respondent 7.
Who is
5,
respondent number 7?
7, 8, my lord. The deputy commissioner. My lord, here, my lord, page 17.
Affidavit in opposition, 5 to 7.
Yes, my lord. Now,
Page.
17, my lord. The Keva decision, my lord. Now, here, Taling Jano, how Taling Jano come into possession of the land, my lord, that has been described, my lord, here. Sri Tanong Saro had a fish pond at Tanong Mangku General School area, which he sold the Taling Jano for rupees 700 only. After purchasing the fish pond from Tanong Sara, Sri Taling Jano started to claim the whole area of Mangku General School, which he claimed to have purchased from Tanong Sara. Now, last paragraph.
PA form along came to Damong and allowing them to move to the passed an order that the amount of rupees 700 on which the Tanong Saro has taken from Sri Taling Jaman to be returned to him. Name the fish consequently So the land of the school area belongs to Tanong Saro. That from today onward, the area will be cannot claim these areas as his personal area. This is of which year?
This is of 1996, man. 19 March 96.
Yes.
Man, here, down, man, last paragraph, man. It has been decided by all Jamlo Mangkur Gams that the land of area, school areas belong to so and so. That from today onward, area where the school RWD unit hospital have been established, Sri Tanong Saro cannot claim these area as his personal area. However, in case in future, if the school RWD department hospital area is left free, vacated, then Sri Tanong Saro being the landowner can claim back the land. No person can malocate. On the condition that if we vacate the area, it is no more in the use of the public community for public utilities. That can only happen. Otherwise, this is decided, my lord, because this land was donated for the public use.
Yes.
Now, once it has been donated, my lord, unless we vacate the area and unless we no more requirement. Since it's still in our existence, it is the hospital is still functioning. Public interest is matter.
You wait for them to vacate to claim your right
Lordship,
over the land.
Lordship, may I? Okay. Lordship may see the affidavit in opposition filed by the.
Just wait.
Yes, this Tanong Saro, which he is saying is my father.
Yes.
They have not said I am not the owner here also. And it is only the medical department who is claiming that the land has been donated by the whole community or other villagers as well. It is not true, Lordship. That I have filed an affidavit in reply to that stand taken by them in the affidavit in opposition. They are the only ones claiming that. Otherwise, the government in page 3 of their affidavit have clearly stated that the land owner is my father. That is clearly there. They're making, being on the respondent side, they're making contradictory claims against each other. In fact, Lordship, I have in the affidavit in reply, which I have filed, I have pointed out that the persons mentioned in the 2004 Kabang, which they have said is the community land. First of all, I was not there in the Kabang. I was not there, nor my father was there. Secondly, the persons who had, which I have sought in earlier, page number 1516, the 1997 Kabang. 1997 Kabang, which I have shown earlier, the same persons who were present in that Kabang are said to have signed in this Kabang. It cannot be, they cannot review such a decision. They don't have that power. This has been done behind the back of my father and me, Lordship. But one thing is there, Lordship. I have shown page number 18 in my writ petition. My father had also made objections when they were repairing, going on further repairing of that. Now the government, can they simply take away the land just like that, saying you have donated, without there being any document, without there being what we are admitting, because the word donation and allowed to stay seems like a same thing. But when you say donation, it means with a willful consent. But what happened here was it was a temporary arrangement, which is seen by page number 18 also, by my father. Just because we have used the word donated in some places, it sounds as if that was done with a willful consent. Now, Lordship, government cannot, the state cannot claim the plea of adverse position and take away the citizens' land just like that. They cannot do that.
Area?
Lordship?
What is the area?
It's only 500 square meters.
At page 18, just I have like the affidavit of respondent 5-7, madam. His father was the signatory, man. I think serial number 1, man. He has accepted, and the decision was made under
1996.
1996 is in my favor. Why would I not have?
Yes. The number 1, serial number 1 is father. He was the president, and he has accepted that.
Yes.
That was because it was allowed to be built at that point of time. It doesn't say that I'm not the owner. Specifically, it is stated that the father, that Tanong Saro was the owner. His ownership has been recognized by this Kabang also.
Condition is stipulated accepted. Condition of this.
Acceptance here is acceptance of a temporary occupation. They have extended their occupation till infinite time now. That is why, as I have shown in page 18, my father had made objections. They have not replied to that.
That's all. That's all.
Lordship, I'm relying on 2020, volume 2 SCC 569.
2020.
Volume 2 SCC 569.
569.
To say that the state cannot, being a welfare state, the state cannot claim adverse position. Para 12.11. And that there is no 12.11. We are surprised by the plea taken by the state before the High Court that since it has been in continuous possession of the land for over 42 years, it would tantamount to adverse possession. The state, being a welfare state, cannot be permitted to take the plea of adverse possession which allows a trespasser, that is a person guilty of tort or even a crime, to gain legal title over the land by invoking the doctrine of adverse possession to grab the property of its own citizens, as it has been done in this case, in the present case.
Yes.
Also, I am relying on the same, Lordship.
But facts are different.
Lordship.
It was not, they have not allowed, the petitioner did not allow.
Yes.
To use the land. It was forcefully taken.
It was taken and compensation was not paid for more than 42 years.
Your case is you have allowed them, and there's a
The,
decision.
the allowing was
a party to the decision.
Yes.
Accepting that in the event if it is vacated, it
Yes.
will be returned back to you.
It was for a temporary.
For the again, when it is not vacated, in view of the Keba decision.
It was
when
for,
you are a
it
party-
it was for a temporary occupation, which had now, which has now become indefinite, Lordship.
Keba decision has not been put to challenge, my lord, as on today.
Okay, okay, that's all.
Obliged.
Heard MS N. Dangan, London Council for the petitioner, and also heard Mr. T. Tagup, London Standing Council for Health Department.
Yes, madam.
Department of Health Services, Government of Arunachal Pradesh. And MSP Pango, London District Council for respondent number
5 and 7, Your Lordship.
5 and 7. What is your submission?
My submission, Your Lordship, already,
I
standing
didn't
council.
understand, I didn't hear what he has submitted.
Okay,
You submit your own.
okay, Your Lordship,
own
public,
stand-
Your Lordship, my submission is public health center is still in existence, Your Lordship. It's not been shifted, Your Lordship.
So you
And
can, you can forcefully take the citizens.
No, no,
Let-
no, Your Lordship, and Your Lordship, the
without due
contention.
process of law.
No, Your Lordship. And the contention of the petitioner is that the health sub center was allowed to the conduct temporarily is totally denied, Your Lordship, as the land has been donated by the petitioner's father, Your Lordship.
Show us where is the deed of donation.
Your Lordship, from our affidavit, Your Lordship.
Not your affidavit. Deed of donation.
Your Lordship. Deed of donation, Your Lordship.
You will not get it in your affidavit.
Yes, Your Lord, from our affidavit,
You
Your
have
I'm
to
submitting,
find
Your
out from
Lordship.
the office. Next para. Challenge made in this writ petition is the order dated page 0408/2017.
Yes.
Whereby passed by the circle officer, Jamlo Mobuk, whereby the complaint filed by the petitioner regarding illegal construction of permanent structure over the land of the petitioner by one Sri Tapir Tamut is found to be is found to be incorrect as the allegations is unfounded. List of next para. The petitioners not the petition. What is further prayer? Any further prayer?
To abstain from illegal occupation of the land, or
Please, it is further prayed that
or to vacate the land.
the further threat for a direction to respond authority not to occupy the land of the petitioner till the decision is taken for acquisition by following the due process of law. Please do. And to vacate the land if the land is not taken by acquisition, by way of acquisition by paying compensation to the petition. Next paragraph. The petitioner claims to be the absolute owner of the land measuring 500 square meters at Jamlo Mongku village at Patu Domong, which the area which is known as Patung Domong, within bracket Domong, Patung Domong. List of, which is under the occupation of the health department for establishment of health sub-center. List of, it is contended that the land in question was given to the health department for establishment of temporary sub-center by the father of the petition. List of. After the land was given to the respondent department, the father of the petitioner you also made a complaint. You had also made a file a representation for compensation.
Yes.
Father of the petitioner and the petitioner have approached the petition, the respondent department.
The father did not ask for compensation.
No,
He said
on various occasions for appointment in the government's job, government service, in lieu of the as a compensation, or to acquire the land and acquire the land by following the due process of law and make payment to the petitioner. List of.
Lordship, father did not make any prayer for compensation. He simply said, since it was given on a temporary basis, kindly stop repairing.
Stop repairing.
Yes, because
Yes.
it was given for only temporary period.
When it was,
This is page 18.
then you write, you delete the father.
This is in 2000.
Petitioner, before that you said, where it is?
Page 18, Annexure 4. It is a letter to the
Before
Director Health Services.
For the last paragraph, you write, on 11/12/2014. No, page 18 is something by your father, by you only. Where is your father's letter?
Lordship, that may be in page 17. I think there is something wrong with my pagination.
17.
Yes. To the Director Health Services.
Which date?
Date is not given, but in the receipt, it is 13/1/2000.
Before that, last sentence. You just delete the father of the petition. You just say in the last sentence, the petitioner on various occasions. Before that, on 13/01/2000, the father of the petitioner had approached the Director of Health Services, Government of Arunachal Pradesh, by way of complaint that since the land was allowed on temporary basis, allowed on temporary basis, allowed for temporary construction of the subcenter, health subcenter. No further repairing shall be made as he has already developed the area into horticulture garden since 1986 to 87. Next minute. Then that last sentence, huh? MS and the learned counsel for the petitioner submits that there is no dispute that the lands belongs to the petitioner. Land in question belong to the petitioner. Although the land was the department was temporarily allowed to use the land by constructing to use the land for primary health center, the land has never been donated, nor there is any acquisition proceedings, nor any acquisition proceeding as undertaken by the respondent authorities. Please stop. She submits that she submits that since the ownership is not disputed and there is no acquisition of the said land, the petitioners cannot be deprived of his property without following the due process of law. Please stop. She further submits that the respondent authority, being the welfare state,
Yes.
cannot claim adverse possession over the property of the citizen. Please stop. Therefore, she submits that the respondent authorities may be directed to acquire the land by paying appropriate compensation or return the same to the petitioner. And also to pay lump sum compensation for occupation of the land without due process of law. Mr. Titagum, Mr. Titagum, learned counsel for the standing counsel for the health department. On the other hand, referring to the various CABA decisions of 1996, 1996. No, not various CABA. The CABA decisions of 1996, as well as and 1990, 2004. Submits that the father of the petitioner has Then you just before that, huh? Before that, MS N. Dungan has placed reliance of the judgment of the Supreme Court in the case of Vidya Devi versus the State of Himachal Pradesh, reported in 2020, 2 SCC 569, para 12, 12.11.
Yes.
In support of her submission, huh? You quote the para 12. '97 also. Where is the 96?
96 is, 97 is in the petition itself, page 16.
But
and 1996 is at page 17, 18 of my
Kaba decision dated 1903, 1996. And where is that? 2004?
2004 is at
Not N, comma,
page
19,
11 of my
third 0306 1997. And where it is?
2004. 2004 is in my affidavit, page number 11. Contractual, file the response number 346. That from page 10, 11 is type copy.
There's no page 11.
Portion of 3, 4, and 6.
Okay, it's a reply. And 0703 2004. Submits that the father of the petitioner has donated the land in question for establishment of, what is this? Primary subcenter, on which the department has established a health center, health subcenter. They submits that in the Kaba decision of 1996, decision dated 1903, 1996. It is this. It was decided that the land of the school area belongs to Sri Tanong Sir, the father of the petitioner. And from that day, the area where the school, RWD Department Oblique Unit Hospital have been established, the father of the petitioner cannot claim these areas as his personal area. However, in the event if the area is vacated, if the land in question is vacated, same shall be returned to the father of the petitioner, Please stop. In 2004,
It's the same reiterated at the event in 1997.
in 2000, the same has been reiterated in the Keba of 1997. Please stop. On 0703/2004, another meeting was conducted wherein it has been clearly decided that no private individual shall be allowed to construct any house for any purpose as it belongs to the community and have been donated for medical complex. Mr. Next one, Mr. Tital Learned Council submits that the petitioner or his the father of the petitioner was also the signatory of the said Keba decision. In signatory of some of the above Keba decisions. Please stop. Neither the father of the petitioner nor the petitioner has challenged the above Keba decisions at any point of time. Therefore, the Keba decisions have attained its finality. Please stop. He submits that once the land is donated, there is no question of acquisition or payment of any compensation. And as such, the petitioner cannot claim the land in question as the father of the petitioner, as his father has donated the land for establishment of primary health sub-center, which is still being utilized for the sub-center in the interest of public at large. Next bit. MS P. Pangu, Learned State Council submits that he adopts and subscribes the submissions made by the Learned Standing Council for Health Department. Next bit. Consider the reconsideration has been extended to the submissions of Learned Council for the Learned Council and advanced by the Learned Council of the parties indeed. And where is the records? No. Where is and have considered the materials on record. Next better. It cannot be disputed that the land originally belongs to the father of the petitioner. List of the father, which was allowed to be used for establishment of primary health sub-center. List of Next bill. By various cable decisions, the land which is used for primary subcenter, primary health subcenter, the by what is it? Appears to have been resolved that the land shall be utilized for the purpose of it has been allowed. No, for the purpose of establishment of health center, which is being used as on date. It is noted that the father of the petitioner has filed an application, has filed a complaint before the Director of Health Center in the year 2000, claiming back the land on the ground that he has already established the horticulture, he has developed the land by establishing the horticulture. No, he has developed the land for horticulture. And not to repair the structure of the health center. The petitioner thereafter, on various occasions, approached the respondent authorities either for appointment in a government servant in lieu of the land given to the
Appointment of his wife, Lordship.
appointment of his wife in lieu of the land given for land in question, which has been given by his father for establishment of the health center. And also for or to acquire the land and pay compensation to the petitioner, as the ownership of the land is not disputed. Next paragraph. On careful consideration of the various cable decisions, it is seen that the land in question belongs to the father of the petitioner. However, same is allowed to be, same was given to the health department for establishment of health center in the health center for the area at Jamlomomku for the people of Jomlo village. Jomlo is a village.
Yes, here it is
a
mentioned. as village.
circle.
It's a circle, I think.
Jomlo
Yes,
Circle.
yes.
Jomlo circle. In a strict sense, no, this no. All this in some of the cases, in one of the Keba decisions, the father of the petitioner was has participated
In two Keba decision.
two Keba decision. One, the father of the petitioner has participated which indicates his agreement to the decision of the Keba. Please stop. In a stricto sensu, the land has not been donated as such for medical, for primary health center, health sub-center. No, not primary. For health sub-center, by subscribing to the Keba decision for establishment of the sub-center over the land, establishment of the health sub-center over the land, I'm of the view that the subscribing to the Keba decisions. Yes, madam. Last sentence. In the strict sense, yes. No, However, by the subscribing to the Keba decisions and participating in the Keba decision, in the Keba, in my book, would be as good as donation.
Sorry for the interruption,
Yes.
but the Kebang were not held for deciding whether or not donation would be made. Kebang was only done because another person, one third person had encroached upon the land.
No, this 96, 97.
Yes.
Two-
One Taling Jannom had encroached upon that land.
Whatever.
That is why Kebang was held.
Ultimately,
By that time already they had occupied the land. The PhD had occupied it.
Is that the land will remain with
Yes.
the department as long as we are there.
That's why we're not saying that what Keba has decided, but in Keba, sum and substance decision is to use the land for medical purpose or whatever. You read the Keba decision.
Yes.
Ultimately. Of course, it is on the basis of complaint by some other person. Keba was conducted, but ultimate decision is to allow it for self-center. Next page. Next page. Having considered that the father of the petitioner had subscribed to the Keba decisions, although land belongs to the father of the petitioner, come on. At this stage, at this, at the, no, not at this, the claim for the land, said land, a claim for the land in question. A claim for compensation, claim for compensation of the land in question, or to return it to the petitioner may not be acceptable, Mr. Acceptable, as the father of the petitioner has given and allowed it to be utilized for the purpose of establishment of health sub-center, that for the interest of the people of the area at large. Mr. Although it is seen that, no, Mr. Although the father of the petitioner appears to have made once appears to have made a complaint not to repair the structure of the health center on the ground that he has established, he has developed the area for horticulture purpose. Come on. Once it is allowed and given voluntarily, same may not give a right to claim back the land by the petitioner. Mr. So, in view of the above, I find, in view of the above, come on, this court finds no ground for the petitioner, no ground to direct the respondent authorities to acquire the land or make compensation, as the land was donated, land was given by the father of the petitioner. And part of the petitioner thereby subscribing to the consequently and thereby consequently subscribing to the decisions of the Keba, that the land in question shall be utilized for medical for public health center. Therefore, there is no merit in the writ petition. Accordingly, same is dismissed.
Somewhere it is mentioned as sub-center. It is primary health.
Primary health center. I'll just one paragraph. One paragraph you write. The case law relied on by the learned counsel for the petitioner has been perused, listed on consideration on the perusal of the said judgment of the Honorable Supreme Court. The no doubt the Honorable Supreme Court has held that so and so, huh? However, defects in that case is totally, is facts of the case is different from the case effect of the present case. In that case, the authorities has taken over the land without due process of law. The claim was made after 30 years,
42 years.
42 years. In that context, the Honorable Supreme Court has held that so and so, so and so. Huh? In the present case, the father of the land, father of the petitioner has given the land for establishment of primary health center, primary health center, which is for the interest of the people in his area, which this court express its appreciation. So therefore, the case related is not applicable in the facts of the present case.
Benevolence cannot be expected from the poor.
Yeah.
Benevolence cannot be expected from the poor. This is the case. Oblige.
This is what? 32. Yes, madam. What is to be done?
May I, Your Lordship? Respondent number 5 and respondent number 6 are private respondent.
Yes.
So this morning they have informed us due to some emergency, they couldn't come.
Yeah. So you are mentioning on behalf of the respondent number 5 and 6.
No, Your Lordship. I'm appearing on behalf of ESMA.
But then you are mentioning on behalf of respondent number 5.
My senior have instructed me to inform
What?
that
Where is
respondent
your senior? Where is your senior? Is listed for hearing. Will hear you. What is this? What is the matter?
It is a matter of land compensation.
Is 1, 2, 3.
Yes, my lord, there case will be part of the compensation amount has been deposited in the account of DCA DLRS. Despite the DCA and DLRS is not releasing the amount.
Why? Why? Who is for respondent 1, 2, and 3?
I have for 2 and 3. I have for 2 and 3.
Yes, you are not filing affidavit.
No, my lord.
Why?
Because my lord, whatever the amount assessed, my lord.
It has already been deposited.
Yes, my lord.
Then why? Who is not paying? Yes.
The land actually is in opposition of ICB, my lord. And I
Proceeding,
deposited the amount to the account of the deputy commissioner. I don't know, my lord, why this money is not being released. Otherwise, it might be this, my lord. In the initial assessment, my lord, the total benefit rate was 37. Now, these people only 6 days come up before this on the report.
What is that impute order? 3005.
Affidavit matter of corresponding number 5 and 6 will be required. Initially, my lord, there was an agreement between the petitioner clan and this is clan of respondent number 5 is they were included as the respondent in the petition. Now this is respondent number 5 and 6. They file application for implement.
Okay, they have been implemented.
And then get the record, but they must have been implemented, my lord. Because of the dispute, my lord, that in between respondent number 5, 6, and the petitioner, my lord.
No, there's
That will be the reason for
a
this
decision of the deputy commissioner on 30th May 2022. Certain decisions that has been impugned here. Who is Silam Sobro? What is this? Samba.
Aningsu Sangba. Aningsu Sangba and
Yeramsu Samba.
Sikamsu Bu.
Aningsu Samba. Sitam Subbu.
Yes. Now they file.
They have implemented themselves. Or
As a respondent, yes, ma'am.
huh?
As a respondent, not as a petitioner.
Yes. They've been implemented on their application or by them.
Not their application.
Then who appears? That's why you are saying on behalf of 5 and 6.
Yes.
On the prayer of MS so and so, her MS so and so, not her, but MS so and so, learned counsel for the petitioner submits that he has been instructed, he has been requested, she has been requested by the learned counsel for the respondent number 5 for adjournment for to seek an adjournment of the matter due as they would not be able to appear. They are not able to appear before the court due to personal difficulties. Let this matter be listed after 4 weeks,
2 weeks.
3 weeks.
2 weeks. Mobilize your answer.
Yes. What is this?
This is regarding the.
You are claiming compensation
Yes.
or what?
Yes, my lord. No, my lord,
So what are the
only issue to be decided here is we are claiming that the land has not been acquired. Only some certain semblance may have been taken up, but then that is not the complete acquisition. And the defense state army, they are claiming that the land was acquired as per law. Now, only point to be seen here is whether the land was acquired as per provisions of law. Or that is the only issue to be looked into. If it has been acquired as per law, then my writ petition does not subside. And if it is found that the land procedure that is prescribed under the law has not been fully fulfilled, then that the claim of acquisition is not a valid claim.
Have you come across any proceedings which has been strictly in accordance with the provisions of law?
Yes.
In the state of Arunachal Pradesh. Have you come across?
Hello?
Have you come across any land acquisition proceeding which has been done in a strict by strictly following the provisions of the law?
Yes.
As of today.
Even
in which area?
Even
which proceedings?
Yes.
Nowhere. Only lump sum.
No, my lord.
Lump sum requirement provisions are being applied.
That also has not been done.
Yes.
The my lord, in my writ petitions, my lord, you also may kindly come to my writ petition.
Yes.
My lord, the basic thing is, my lord, at pace, I'll start from annexure 3, my lord. Page 58, my lord.
Why two repetitions? It's different area. Is it for different area?
Different area. Same location,
But different area.
different area. One area comes under Rupa area and one comes under Simshung area, but it is under the Tenga garrison. My lord. Now, my lord, this matter has been disputing since long back. And in fact, we had also approached the National Commission for Scheduled Tribe. But since certain issues were to be determined, and since NCST could not go into that determination, so we have withdrawn that, and then we are filing. But in the NCST, they have filed their written statement also. But if we see this written statement, the position will be very, very clear.
Yes.
Please come to page 59 onwards. 58 is an answer to RTI filed by us, and where it is, the Deputy Commissioner has clearly stated that there is no acquisition proceeding, no records of acquisition proceeding. Now, at page 59, may I read, my lord?
Yes.
To the Deputy Commissioner says, point number 2, my lord. It is intimated that as per Government of India Ministry of Defence letter number such and such that 18/9/1971, an area measuring such and such under Tenga garrison has been acquired by the Defence Council, the Defence Department. However, Parawas reply on the NCST letter such and such is forwarded herewith as annexure A and B. Now, let us come to page 60. This is the annexures. Here, the basic facts which we have raised in these writ petitions has been clearly provided.
This is a parallels to the National Commission.
Yes.
No, see, why you are not why you are saying that this has not been properly, provisions has been followed while acquiring that.
No.
Are you disputing the acquisition? No.
I am disputing.
You are saying that there is no acquisition.
There is no acquisition.
Okay. They are saying that there is an acquisition.
There is an acquisition.
Show us where is the
Yes.
what provisions
Yes,
of law
my
you
lord,
have followed?
yes, that I come to that. My lord, this land was taken in 19
Just wait. Let me.
on rent. Then, my lord, in 1971, the MOD has given a sanction. Then, my lord, procedure was accordingly. Your lordship may take my affidavit of opposition. That is, the lordship may turn to.
Yeah, just you tell us.
1119.
Before we
1119,
before we refer to the, you
Yes.
tell us. 1198.
No, I 119. 119, my reply to the
What is 119? 180.
page, my lord.
Which writ petition?
No, my affidavit in opposition.
Affidavit in which writ petition?
This is 186.
186. This one. 186 or 187?
186.
Well, then in that case, we are taking up item number 34.
34. What is the difference?
No, there is not
There is no difference.
Because if your lordship may take, it's the same case.
186, we can.
186, my lord.
186 or 187, we can take, no problem.
186. One
187 is item
33, 32, 33, and then 186 is 34.
only the different area.
Only one different.
The reference is same. Facts are also
Facts are same, claim are also same, dispute are also same.
different persons,
Only
different areas.
Yeah, only the
Different petitioners in different area.
Yes, same
location,
garrison,
but
but two
different
parts.
location.
Yes,
Yes, your lordship may count my activity in position.
Yes.
Para 6, page 119. For your sake, your time, my lord, because in 1809-1971, the Ministry of Defence accorded the sanction for acquisition.
199.
119.
119.
Acquisition of 194.3345 acres. And out of which, my lord, 236.50 acres was in urgency clause under section 17. and 957,8345 was
Which-
normal
which-
procedure.
which-
Your Lordship, ma'am, have you got it?
Which page?
119 on my affidavit. No,
119 or 199?
no, 119, sorry, 119.
Where it is?
Paragraph 6, my lord.
Okay.
Very well. Just tell you read it because we have made it in detail, that will be convenient for us. But then with regard to the statement in paragraph 7 of the resolution, the answering statement begs to state that the government of India, Ministry of Defence, by letter number so and so dated 18/09/1971. Accorded sanction for acquisition of an area measuring 1,194.3345 acres. Out of which the area measuring 236.50 acres of land under urgency clause under section 70. An area measuring 957.8345 acres of land in accordance with the normal procedure of the Land Acquisition Act 1894 at time. Moreover, prior to the above mentioned acquisition sanction, the land measuring 1,112.65 acres were under hiring, and details of these hired land were given in MEO dashboard later dated so and so on 01/03/1973. As these documents are 60 years old, a few documents are available with officer of the defense state officer dashboard. The detail of the same are as follows. These are the documents that you are asked for. 158 acres of land in Tengau were hired by the Defense Department under administrative approval of number so and so dated 13/12/1965. By later memorandum dated so and so. Then 222 acres of land in Rupa were hired by the Defense Department under administrative sanction number so and so dated 13/12/1965. By memorandum financial sanction so and so. Out of which 207.47 acres of land acquired by the Defense Department and 14.53 acres of land proposed to be released. After sanction of the accorded by the Government of India Ministry of Defence by letter number so and so, dated 18/09/1971, the Government of Arunachal notified under Section 4 of the Land Acquisition Act 1894. By notification number so and so, dated 29/04/1972, published in Arunachal Gazette on 16/05/1970. Thereafter, the Government of Arunachal Pradesh issued declaration under Section 6 of the Land Acquisition Act 1894, by declaration number so and so, dated 13/10/1972, published in the Arunachal Pradesh on 16/11/1972. The award under Section 11 of the Land Acquisition Act 1894 for area measuring 1,090.94 acres have been declared by the Deputy Commissioner, Bomdila, by memo number so and so, dated 29/02/1973. And the award under Section 11 for the area measuring 25 acres was declared by the Deputy Commissioner, Bomdila, by number so. My lord, these are the documents we have annexed. Your lordship may now turn to 158.
So these are tally with the area claims by the petitioner. Is it you have just said that
Yes, subsequently, certainly some difference were there, and some of the land were released, and whatever the acquired payment has been already made in 1970.
No, it's okay. You tell us the area specific location which
Yes.
they are claiming. Has it been acquired?
Acquired and payment
You
has been made.
show us to that.
Yes, then your lordship.
Not that in general, because it's a big area.
Yes.
What is the area of your claim? What is the total area?
In here, 672 acres, and
Acres.
in the another one, it is 432,
So 1,000.
around 1,000.
1,000. No, they are saying. They are also saying 1,090.
Yes, we have not denied. We have not denied.
It's
Yes.
it's telling with the claim of the
Yes.
area is same.
Area is.
The total area.
Area is only small pockets are disputed, rest of the things are not disputed, some of the land were recorded back. But it's a small area, but it is more than 1,000, nearly 11.
So according to you, the land, the area, the location which they are claiming, this has been acquired, and then compensation has been paid.
Yes.
Show us that is specific, not the entire thing.
Yes, my lord, then your lordship may turn to page 158.
158. Nineteen
158 and extra one, my lord. So this is the figure we have given. Acquisition level in Tangale, as your lordship asks. This is the letter. I am directed to convey the sanction of the president to the acquisition of 1,194.345 acres of land at Tangale at an estimated.
Some other date will not be able to complete today.
I think need one.
Yes.
Mellon, may I just-
No, I have not, first I have to hear him. I just wanted to know, because of the paucity of time. I just wanted to
Mellon,
have the
may I
thought.
just summarize one just simple
I
aspect.
just wanted to have
This
I mean,
lane-
first-hand knowledge of the matter.
This lane, total lane, there are so many, even, therefore, there has been always a dispute. In 2014, I have enacted or later also, in 2014, even the Commissioner Land Department has said that land acquisition has not been properly done. Go and do it again, directed. In any case, there was some confusion. So therefore, in 2003, there was before that, there was a high-level meeting at Delhi in presence of the Minister of State Defense, and where our Minister, Mr. Kiran Rijiju, was also present. There, it was decided that once and for all, you go find out which area are under what category. So in 2003, one cadastral survey was made. As per records, two lanes were identified. One is the defense A lane, where this lane of this both the writ petitioners with these two writ petitions comes under. This is called defense A1 lane. Another is 177 acres of land that was called as excess land, and that excess land has been acquired as per law. We have received the payment also, and which they have annexed here. And my lord, regarding this defense A lane 1, the dispute was still there. It was not very clear. So therefore, in their affidavit, they have annexed the proceedings of the 2003 exercise. It is annexes 7 of the affidavit of opposition, my lord.
It's okay, not today. It's difficult.
Because I'm really going on a hurt. And secondly, what my learned friend is saying, the RBI that we have confronted, we have not agreed with that.
Anyway, we'll hear you. I just want to have the first-hand information. And
Malad, just one line only, Malad.
No. We will not be able to complete today. That's the reason. Otherwise, we'll hear it. Don't worry. When?
But can it be kept as a part of and then fix a date?
So let it.
Or tomorrow?
Let it come after vacation. We will take
No,
nearly 2
Malad.
hours.
Before
They have
that,
waited
not
50
before that.
years.
It speaks for
Because they have waited 50 years, my lord. They have
Fixed-
come before your lord.
fix for hearing just because we have we don't have the
Malad,
time
in that case, either on the 16th or 17th.
after that. Somewhere
I need more than 1 hour. Then he will be required.
No, Malad.
then somewhere we commencing from
October.
23,
Yes.
24
Yes. 23.
this month.
Then let it come on 7th. The 17th, my lord.
Huh?
17th of this month.
No, after that.
Because I
24, 25,
24.
26. Huh? 25,
No, from here to
24.
24, 25, 26. Any day that week.
And my humble
Or maybe after that.
my
Then
humble-
first week.
My
First week.
prayer is among that hearing list, it should be on top.
Why? There's no urgency. You have waited for how many years? 60 years, 60 years.
60 years, more than 60. Let it come, my lord, in 22nd.
3rd of October.
Oh, yes.
Make it 3rd of October or 4th of October. No, 4th
At your
is,
convenient order.
4th is the last day. Make it third,
Yes. Thursday, Friday.
third of October.
My lord, may
He has not.
Yeah,
I'll furnish
our
the copy
senior
right
person,
now.
yeah.
They said they have not received the
Yeah.
copy. I'll furnish it now.
You furnish it immediately.
Yes.
You'll have to clarify.
Yes, yeah, that is why.
Yes.
We need
Here's
his
a
affidavit.
claim and counter claim.
Yes.
So you have to clarify. You are the authority.
Without his affidavit, we cannot do anything.
Oh.
We'll give it.
Have you filed the affidavit?
No, we'll
You
have to
have to
see his
file-
affidavit first.
Huh?
But
It's a fight between the petitioner and the defense. So you are the authority to acquire the land, both of you.
yes,
DC and
Therefore, also we are
collector
asking for
and
the
district.
copy.
They are the
Because we
owner of the
we
land.
have to get it verified from the authority. Because claim of
That's
the.
why, that's the reason. Why this is been fixed for hearing when pleadings are not completed?
No, my lord, government has already filed their affidavit. They have,
We have already filed. also.
You have
But-
not filed.
but
I
the-
have not paid.
But the copy was not served to us also.
Are you supporting him or supporting the defense?
In my opinion, we are supporting the petitioner also.
Okay.
But since there's a claim from this particular respondent that acquisition was done, I'm the acquiring authority also.
Hmm.
So if that
So
is
you-
there, then copy is
Right now.
required.
Right.
Had Mr. T. Learned counsel for the petition, both the petitions, huh? Same order. And also heard Mr. Doloy. Why Doloy? Learned senior
Senior panel counsel.
Senior Panel Counsel for Union of India. Let this matter be, let these matters be listed for hearing on 03/10/2024. In the meantime,
I'll furnish it
the
quarterly.
Mr. Doloy Learned Senior Panel Counsel shall furnish the copy of the affidavits filed on behalf of the Union of India to the Learned Counsel for the respondents.
Yes, ma'am.
Learned Counsel for the Learned Standing Counsel, Mr. D. Kamdugan, Mr. S. Tafim, Learned Senior Government Advocate. No, not in the meantime, huh? You just said the Mr. So-and-so shall furnish the copy of the affidavit, huh? Then next, in the meantime, the respondent number, where you are?
5.
Respondent number 5. Come on, Department of Land Management shall file the affidavit.
Yes, ma'am.